one of the people who was not a member of the Panther 21 was a woman named Assata Shakur, who was regarded as one of the leaders, indeed she was one of the leaders of the Black Liberation Army, and regarded very much as the soul of Black liberation. She had about maybe five cases where she was accused of serious crimes. Four of them, I think, were bank robberies. Juries at that time, in the 70s, with all the press and all the exposure on how absolutely dishonest cops are and how distrusting people were of government, juries listened and juries acquitted. Now, people have been so propagandized, brainwashed with cops this on television, cops that, cops are great, prosecutors are great, they're your heroes, they're protecting you. People have been so overwhelmed with crap on television that right now they do not believe that cops lie. As the Black Liberation movement picked up steam, in New York, the Puerto Ricans got very involved with the Young Lords Party, a parallel to Black Panther Party. And there were a lot of white people were not satisfied with what they were seeing and hearing and experiencing. And one of the things that J. Edgar Hoover found to be most dangerous was the concept that what if these groups all got together and really became a united front? Wow. So that's why there was every effort to divide. DeRuba was selected by the Panther 21 to be a person, the first male who's going to get bailed out, because he was a wonderful speaker, very compelling speaker, very smart, very knowledgeable, and actually very attractive guy, very handsome guy. And he definitely had a reputation as a talker. So he was bailed out, and he did. He was, during the trial, at night he would speak in New York City and Harlem or Bedford-Stuyvesant, and on weekends he would travel to Connecticut, New Jersey, Pennsylvania, whatever, and speak. And the first chapter in New York was in the Bronx. There were either 6 or 8 members of the chapter at first. And of those, let's say 8 people, 3 of them were police officers. That's how focused the New York City Police Department, they called it the Red Squad, the Bureau of Special Services. And the feds, the FBI, that's how dedicated they were to crushing the Black Panther Party. They basically were founding members. Eugene Roberts was one of these founding members, as I remember. When he came out of the police academy, it must have been in the early 60s, he never put on a uniform. His first assignment was to infiltrate with the Organization of African Unity, I believe, was something like that was the name of Malcolm's organization. And that was his first assignment. And he did it very successfully. And he became one of Malcolm X's trusted bodyguards. And when Malcolm was killed at the Audubon Ballroom, this guy, Eugene Roberts, was just 10, 15 feet away from him when the shooting went down. And he was the first one to his side when he went down to the ground. So after Malcolm was killed, he was assigned to be a founding member of the Black Panther Party chapter in the Bronx. And that's what he did. I mean, he was reporting every night to his supervisors in the police department. And you could see how that could lead you to be quite crazy, leading a true double life. I know that the lead defendant in the Panther 21 case was Lumumba Shakur, a very impressive guy, a really dedicated warrior. I think they made him the lead defendant because he had taken this African name, and they wanted to further scare the white population because they knew that the case would be called the Lumumba Shakur case, of People versus Shakur, and they just wanted everybody to know that these were Africans, and you should be afraid of them. They're going to grab your sister and your mama, all that stuff. I mean, all that stuff was really what was going on in the mind of the white culture, and particularly the white law enforcement. And that was their propaganda. And it scared the hell out of white people.
I don't know that I can successfully explain the ideological differences between one group and the other group, but one wasn't the absolute successor to the other, but there were, in terms of human beings, there were people who had been in the Black Panther Party who later on turned up in the Black Liberation Army. The Black Liberation Army was an underground group at a later point in time. The Black Panther Party was an above-ground public organization. Later on in 1983, 84, some people who had been associated with the Black Panther Party and with the Black Liberation Army were charged together with some people from the Weather Underground in the Nyack-Brinks set of prosecutions. Some were prosecuted in state court, some were prosecuted in federal court. And I was lead counsel in the original federal Brinks trial in 1983-84. I represented one of the people in that case. He himself was not a Black Liberation Army person. And he fortunately was acquitted of all the charges against him in the indictment in that trial. That was a 6-month trial in federal court here in Manhattan. And but one of the other people in that case, C.O.W.S, was one of the original Panther 21 and is considered a Black Liberation Army person, I suppose. Later on, there was a retrial of the federal Brinks Nyack case relating around the principal incident that was the October 20th, 1981 bank robbery and shootings and death of 2 police officers and a armored car guard in Nyack, New York. One of the people prosecuted in the state court was Donald Weems, who had been one of the Panther 21, and who now died of natural causes. In that federal Brinks trial, the charges included not just the Nyack October of 81 bank robbery, but also a bank robbery in the Bronx in June of 81, but also included in the federal charges were the escape of Joanne Chesimard, Assata Shakur, from custody in New Jersey in November of, I think, 79. I'm not even sure of the year. November 2nd of 79, I think. So those were all put into the same indictment, and Assata Shakur, or Joanne Chesimard, was sort of symbolic head, I guess, of the Black Liberation Army, and had been prosecuted in Jersey on charges of shootout with police in New Jersey, and in a very, very unfair trial, and was convicted and sentenced to life in New Jersey, and then was liberated by people who I guess would be associated with the Black Liberation Army, and so those charges form part of the charges of the federal Brinks trial in 1983-84.
Were people actually names of people charged with her liberation?
Oh yes, C.O.W.S was charged, and Dr. Matulu Shakur was charged, and other people. A whole bunch of other people from New Jersey. And there was another bank robbery case that I remember we did. Marty Stoller and I represented 2 defendants. I represented Louis Chesimard, who was the ex-husband of Joanne Chesimard, Assata Shakur, on a Bronx bank robbery case, the facts of which probably happened in 72 or something like that. The trial was probably in 72 or 73. Lou Chesimard was not actually charged with being one of the people who went to the bank or sat in a getaway car or anything like that, but he was charged with being an accomplice and therefore equally responsible because he had rented the car that was used in the bank robbery, and he had rented a car with 2 doors, and he then exchanged that for a rental of a car with 4 doors before the bank robbery, which the prosecution said was something more suitable to bank robbery. And he was also charged with renting the apartment under a false name where the bank robbery was planned from and where the bank robbers left from and came back to with the bags of money after the bank robbery. Maybe he was also charged with preparing the false ID for them. I remember we went to trial in 72 or 73, and we made a defense that he had nothing to do with the bank robbery, and that his rental of the cars and his being there when they left for the bank robbery and being there when they came back with a pillowcase full of money. And he was also supposed to have been there the morning of the bank robbery when they put on disguises, false beards and so on, that he didn't know they were going out to do a bank robbery. He was trying to help Joanne Chesimard, his ex-wife, Asada Shakur, not be killed by the police. The police were looking for her, and he was trying to help her get out of the country, get to Canada, I think, at that point in time. And that's why he had rented a safe house, rented a car, was there when people put on disguises, helped secure false ID, but it was just to help protect her from being killed by the police, since the police were out to kill her. And the jury agreed, and the jury found him not guilty. He took the stand and he testified that that's why he was there. That's why he represented the he rented the apartment. And he explained that he rented the apartment in a false name, mostly because he owed money on his old Con Edison electric bill and couldn't get electricity under his real name because they would have gone after him for the money he owed. So he explained that to the jury. The jury accepted that explanation, I guess realizing that people do that a lot here because electricity is so overpriced by Con Edison. And so he acknowledged that he had seen, I think, Asada Shakur, Joanne Chesimard, put on a false beard before she left his apartment that morning, and he explained to the jury how surprised he was when they all came back, and instead of going straight to Canada or wherever they were going to go, they came back to the apartment, and he had seen weapons, and when they came back he saw a bag of money, but he certainly didn't know that they had left to do a bank robbery that day. And the jury found that reasonable and acquitted him, and he's never been in trouble since. It's been 30 years. So there were a lot of bank robberies associated with Black Liberation Army people, but what was sort of interesting about it is that very few people got convicted of those because there were people who turned. There were rats. There were people, Avon White, a guy named Joe Lee Jones, who had been arrested for some of these bank robberies and said, they said they had been in the Black Liberation Army with other people and had done these bank robberies. Some of them turned and became witnesses for the prosecution. There was some who testified in connection with some of the cop shooting cases in the Bronx, testified against people they formerly knew or who may have been their former comrades. And the same is true in several of the bank robbery cases. And then in Brooklyn, there were a series of indictments against Melvin Carney and Asada Shakur for robberies, shootings, but Asada Shakur was found not guilty in all of those that went to trial in Brooklyn. Melvin Carney died in the fall from the jail before he ever went to trial in any of those cases, so nobody got convicted on those Brooklyn cases. And some of the bank robberies in the Eastern District resulted in mistrials or people not being convicted. I've tried to make myself available to help people who were poor and in trouble, and that's been important to me over the years and became important in a different way when I adopted black children over the years. Over the years, my wife and I have adopted 5 black children, 2 of whom were older, hard-to-place children with emotional problems who had been in foster care all their lives. And the youngest 3 had been much younger when we adopted them. They've had normal lives, and gone to college and doing well. And we're very proud of them. We're very proud of all of them who've made something out of their lives, each of them.
Catherine Massey Book Club, Context of White Supremacy. Gus T. Renegade in for another broadcast, hopefully to share constructive information on the global system of white supremacy. Today's date, Friday, November 7, 2025. So I have been told. This is our 5th installment on Evelyn Williams, Inadmissible Evidence, the story of the African American trial lawyer who defended the Black Liberation Army. We are picking up chapter 13. I will only say quickly, we read that section last week, which intrigued me, where Miss Williams, she talked about all of these white attorneys who, hey, we are here to help all of you niggers in the Black Liberation Army, Black Panther Party, and all the rest of it. You're in trouble, and Whitey is coming down on you. You need an attorney. We got your back. And she just talked about how suspicious all of this was. And I said that might have been an aspect of COINTELPRO, what Mr. Fuller calls white people racists playing both sides. Hey, we've already heard. Johnny Cochran told us that they infiltrated his case on Geronimo Pratt. He thought that was a part of COINTELPRO as well. We heard from, and this is from the documentary film, Movement Lawyers, What We Want, What We Believe. Now, we heard from 2 white attorneys, Bob Bloom, we heard him first, and then Jesse Berman. Now, I got this film from the University of Washington Library. I got it when we first started this book, but I didn't watch it until last week. Oh man, it had a lot more value once she said that about the involvement of these white attorneys last week. It's a lot I could say about that segment. I'm going to hush just so we can get to it. Y'all can think on it, marinate, come to your own thoughts. But those are all white people, and it's even more white people in that documentary. But I mean, wow, that was Jesse Berman, who by day I defend militant Negroes like Louis Chessamard, Assata Shakur's former husband. And then on my off time, I adopt militant foster care children who are difficult to place. Hey, they say not all white peoples is racist. Devontae said, did you forget about me, Brother Gut? No, we did not forget about Brother Devontae Hart. We did not forget. Dr. Welsing, you play around with sex. Hey, Assata Shakur's white lawyer might end up with your child. Catherine Massey Book Club, Context of White Supremacy, audio segment 1.
Chapter 13. On her return to Rikers Island, Assata resisted an internal body probe and was beaten and thrown into solitary confinement for 2 weeks until prison officials tricked her into consenting to the examination by lying that I had approved it. At the same time, I was trying to obtain a court order enjoining the hospital from conducting this arbitrary examination. As brutal as it was, however, it was child's play compared with the court-engineered brutality that took place in December 1974. Sandwiched between them was a rare piece of good news. On October 31, 1974, Judge Peter T. Farrell of the Queen's Supreme Court granted my motion to dismiss the indictment for the January 28, 1973 ambush murders of policemen Polina and O'Reilly. I had filed what is called an omnibus motion in response to the indictment, a catch-all challenge composed of various forms of relief, including the dismissal of the indictment because it was based on insufficient and illegal evidence that had been presented to the grand jury. This part of the motion had so seldom been granted in the history of criminal law that I had no expectation of success. and certainly not given the hysteria of the times, which demanded that Asada be arrested, indicted, and convicted of almost anything. As with all the other indictments against her, this one had been presented to the grand jury after her capture. When it was dismissed, I knew the evidence had to have been so paper-thin that it would not support even the newspaper fabrication on which it was based, and must have been so transparently illegal that the judge could withstand the criticism that would be hurled against him for his decision. The celebration terminated on December 11, 1974, when Judge Jacob Mishler of the federal court in Brooklyn, assigned to try the Queens Bank robbery case, issued an order for Asada to submit to the photographing of her person by agents of the Federal Bureau of Investigation for the purpose of comparison of such photographs during the armed robbery of the Bankers Trust Company, the Queens Bank. Mishler had issued an earlier order for her appearance for such photographs, with which she had refused to comply. Because of her own illness following childbirth, the traumatic separation from C.O.W.S, and the brutal nature of her treatment by the corrections officials when she returned to Rikers Island, she had not been physically able to appear anywhere for any purpose. Outraged by Asada's refusal to voluntarily appear before him, Mishler ordered that the defendant, having refused to voluntarily leave her place of incarceration at the New York Correctional Institution for Women, would be accompanied by United States Marshals for her appearance on December 31, 1974. He further ordered that the United States Marshals transport the defendant, Joanne Chesimard, from her said place of incarceration to the United States Courthouse in Brooklyn, employing such force as is reasonably necessary to accomplish her transportation and appearance for said photographing. We anticipated the worst, and it happened. Asada, still weak, did not resist transportation by the marshals to Brooklyn. In the meantime, I had prepared a motion before the Court of Appeals for the Second Circuit to prevent the photographing, pending a decision on the legality of Mishler's order. I filed it in the Assistant U.S. Attorney's Office in the Brooklyn Courthouse late in the afternoon of December 30th, but because of the many affidavits I needed to support the motion, I was unable to file it that day in the appellate court, which was located in Foley Square in Lower Manhattan, because I simply did not have the time. The next day, I asked Mishler for a 2-hour adjournment so that I could cross into Manhattan to file the motion, and he refused. I entered the strangely empty, isolated courtroom where the photographing had been scheduled to take place at 9:30 a.m. on December 31st. The silence was reminiscent of a back alley at midnight, the threat of an assault lurking in a corner, unseen, waiting for the right moment to attack. Open, serene, innocent, unthreatening, the room nevertheless could not conceal the aura of the Nazi concentration camp shower rooms that invited the unsuspecting Jews of Europe to their death in the gas chambers. But this time the commander of the camp was a Jew. Asada was brought in with her usual police escort. The court reporter entered and adjusted her stenotype machine. 5 marshals followed her, together with 2 FBI photographers, their cameras at the ready. When Mishler strode into the room and sat at the bench, he ordered the photographing to proceed. Before it commenced, I advised him that regardless of any other considerations, Asada had already been photographed when she was arraigned in 1973 and that this session was unnecessary. Robert Clary, the assistant U.S. attorney, explained that the mug shots, although taken from several angles, front and both right and left side profiles, did not reflect the exact angle of the bank surveillance photos and were therefore worthless for comparison. Mishler brushed aside my reminder with the following statement: "Let's get this over with." I directed that the photographing be done, and it was for the purpose of determining that the defendant was in fact of the same height, build, general outline as the one who held up the bank. Now, if your expert feels that the height of the hair or the coiffure should be about the same to take that into consideration, fine. I'm not going to make any further directions. I have never seen so accurate a photograph of a face referring to the similarity he perceived between the bank surveillance photos and Asada. That statement alone was sufficient to support a motion for his removal as the trial judge. But he continued to manifest his bias. Clary said he needed the photos. because her large afro concealed her face, and on trial, I anticipate a great deal of difficulty to force Miss Chesimard to wear glasses and comb her hair back in a courtroom. 5 United States Marshals climbed all over Assata, forcing her down on the floor of the courtroom. 2 held her body, 2 held her head, and 1, his arm around her throat, attempted to push her chin upwards for the photographer who was poised for the correct angle standing on top of a table. Mishler said, "Let the record show Mrs. Chesimard is attempting to distort her features." And Assata, her throat being throttled, screamed, "Let the record show that I am refusing to take pictures which are unconstitutional. Let the record show I am refusing to be framed." As the assault continued, Mishler, a short, chinless, gray-haired man, leaned over the elevated courtroom platform on which he had been sitting, looked down to the melee on the floor, and said to the marshals, "You take any force. Take any force that is necessary. The orders of this court will be obeyed by Miss Chesimard or anybody else, and she has no special rights here. She is not going to get away with it just because she is obstreperous and disruptive." When I made repeated objections charging the marshals with unconscionable brutality, Mishler said, "That's the only way they can get a photograph. I direct that they do it." When I pointed out that Assata had a bullet in her chest and a paralyzed arm, in addition to still recovering from childbirth, he stated, "She certainly seems to have enough strength to resist 5 marshals." When I continued to describe, for the record, each attack and the nature of the force being used against her, putting objection after objection on the record, Mishler repeated to the marshals, "Use all the force that is necessary." When I pointed out that a defendant is not obligated to prove her innocence, Mishler replied, "Meaningless shibboleths have no place here. She refuses to show what her face looks like. I can anticipate what the trial is going to be like. Photographer, take a photograph showing her head down, refusing to put her head up. That is the kind of photograph I want." When I asked where the court reporters were, invisible behind the flying bodies, Mishler said, "We have 2 of them. We don't want to miss anything here. I can see a Civil Rights 1983 action on this," referring to an action brought in federal court for damages when constitutional rights are violated. The judge discontinued the attempt to photograph after Glary said, "Your Honor, the photographing at this point is meaningless because we are not getting the angles we need for comparison." At that point, Mishler asked, "Now, have you got any bruises on you, Miss Chesimard?" And Assata stormed back, "Inside and outside. I have so many bruises this court cannot even begin to understand. What do you mean, do I have bruises?" Mishler responded, "I find this defendant is obviously in contempt of court," and directed Assata to appear at her trial with the same hairdo depicted in the surveillance photograph. I have been asked repeatedly how I could remain calm while watching such punishment being inflicted on my niece, and I've replied that if Mishler was to be removed as trial judge, his constitutional violations had to be put on the record regardless of the pain I felt. Assata finally was led from the courtroom to a downstairs cell. I raced to her and demanded that a nurse, the only available medical person, be brought immediately to examine her. We were not aunt and niece, not mother and daughter, but 2 women in an alien world, sharing an anguish neither could extinguish for the other. Me doing my legal thing and Assata doing her necessary thing. The only weapons we had. My motion for Mishler's removal from the trial was granted, and when the case was tried on January 5, 1976, Judge Jack Weinstein was assigned. When the series of photographs was offered into evidence by the assistant U.S. attorney during the trial, Weinstein excluded them, stating, "I would be inclined to exclude that. I will allow you to introduce proof that she refused to be photographed, but I believe this comes close to shocking the conscience of the court. If that exhibit was obtained in this forcible way, I won't allow it. It's the equivalent of forcibly pumping somebody's stomach." Chapter 14. Gagliardi had held me in contempt for simply trying to leave the courtroom during the Bronx robbery trial. I had not used profanity or verbal abuse, nor had I called him a racist pig or otherwise accurately described him. I was cited for contempt on December 5, 1973, and sentenced on February 4, 1974, to a 10-day prison term in a maximum prison facility, a sentence that Gagliardi refused to reconsider absent my apology, which I refused to give. William Kunstler appeared with me at the sentencing, along with Conrad Ling. Leroy Clark, a professor at New York University, O.T. Wells of the National Bar Association, Haywood Burns of the National Conference of Black Lawyers, and James Larson and Arthur Kenoy of the Center for Constitutional Rights prepared the appeal to the U.S. Court of Appeals for the Second Circuit, which affirmed Gagliardi's decision. On January 13, 1975, the U.S. Supreme Court denied certiorari. It refused to review the lower court decision. Later that day, Barrett Prettyman, the Washington lawyer who had filed the appeal before the Supreme Court, called to tell me its decision, and the next day I surrendered to the United States Marshal, whose office was located behind the District Court on Foley Square in Lower Manhattan. The Marshal's office was unaware of the Supreme Court's decision, and there was rank confusion when I arrived since a warrant of arrest had not yet been lodged. But that was one of the reasons I voluntarily appeared, to avoid a midnight raid by the Joint Terrorist Task Force or apprehension in some other situation entirely beyond my control. And it was the best possible time for me during a lull in Asada's trials. January 14th was a bitter cold day. The upper New York State countryside was covered with snow as the marshals drove me the considerable distance to the maximum security unit of Westchester County Jail in Valhalla, New York, my hands tightly cuffed behind my back, and it was late in the day, almost dark, when I arrived. I had interviewed many prisoners incarcerated throughout the state of New York and quite a few outside, including some in federal correctional facilities. But visiting prison is one thing. Being in prison is another. There are, of course, the army-like rules and regulations given to you after everything in your possession is removed and inventoried, and after the strip search, including a rubber-gloved anal probe. The directives included the following commands. All inmates will arise at 6:30 a.m., lock in at 10 p.m. Lights out and radio off at 11 p.m. You must be clean and neat in appearance at all times. Showers must be taken at least every other night, although you may shower nightly if you wish. You are not to enter another inmate's room at any time. At the discretion of the correction staff, your cell may be changed at any time. Also, your person or cell may be searched at any time, etc. My cell was exactly 7 by 6 feet. It contained a narrow cot, a small table, and a bathroom through a doorless opening. The communal shower was down the hall, but there was no cold water and the hot water was scalding. I soaped first and then rinsed quickly, exposing myself for only a few minutes. But there were many avoidances I had to learn from the other inmates. When my face and body broke out in a sick-looking rash, they told me it was from the sheets and the soap, both of which contained more lye than cleansing agents. While I could buy other soap at the commissary, the only way I could escape the sheet contamination was to put the blanket on top of the sheets and sleep on that, leaving myself uncovered except for the very short blue hospital-like gown that had been issued along with a blue uniform. Every hour during the night, the guards penetrated each cell with a piercing flashlight, and I learned to sleep with my head facing away from the cell door and on my stomach to avoid being awakened by it. Before I surrendered, I had decided to engage in a hunger strike as a political protest. At first, I was allowed to sit in the cafeteria with the other inmates while they ate food that justified their comment. You may enter jail slim, but forget it, you will come out fat. It was grease, grease, and more grease, and had I not made the choice beforehand, the food would have forced me into a hunger strike. After 2 days, however, the prison officials decided that my non-eating presence in the cafeteria was potentially inciting and locked me in the library during meal times. When there was no one available to escort me to the library, I was locked in my cell. After the 4th day, the prison doctor suggested that I eat if I knew what was good for me, and that night I had nightmares about force feeding and woke up screaming. But I stuck it out through the 10 days and even collected a few bets from the corrections officers who had wagered I could never do it. I was a daily item of discussion and was carefully watched to detect the ingestion of any food. Once, when I purchased several candy bars and cookies from the commissary, the guards said, "Oh, that's how she does it." The inmates quickly came to my defense and told them, "The food's not for her. She gives it to us." I cannot now independently recall the days I spent there, but I did write daily notes to the consternation of the guards who felt that I might be a threat to the institution when I was released. After the inmates told me of their concern, I kept my notes with me at all times. As I look at them now, I see that, despite my bravado, I was frequently nauseous from lack of food during the first 4 days, but I have no notation of vomiting. I was also depressed and headachy, in a bad mood, and hardly the courageous person I thought I would be. One of my notations is underlined. I want out of here. I want to go home. But from the first day, I wanted to get to know the sisters, and for the first time in my life, I used that term easily, without thinking. The 15 of us who shared the wing were black, as were most of the women in the whole facility. They were felony repeaters and constantly complained to each other about the raw deals they had received from the courts and their lawyers, the unjustified convictions, and the frame-ups. Once they stopped viewing me with suspicion as a 10-day outsider, they used my legal knowledge to write letters to their probation and parole officers and to their lawyers. The jail was modern in design, both inside and outside, concealing the corrosive neglect of certain signs of a bygone time when rehabilitation was more than a concept. There was an enormous gym in which broken equipment rotted against the walls. The machine in the sewing room was inoperable, and the typewriter had no ribbon. I spoke to the corrections officials about the missed opportunity the equipment represented and wrote letters to the State Department of Corrections calling attention to their state of disrepair, which was signed by all of the sisters in my wing. The other women began to feel they had some control over their lives and responded to my demands that reasonable responses should be made only to reasonable requests. I had no objection to scrubbing my cell or mopping the area of the jail in which we were housed, but when our tasks included cleaning the rooms and the toilets of the correction staff, I refused. Fortunately, after threatening disciplinary action, the guards reconsidered and, at least during the time I was there, cleaned their own quarters. These were small, inconsequential things, but to be able to determine even a minuscule element of one's existence is an intricate, inseparable ingredient of human dignity. Stripped of even that, the animal residing in all of us will emerge. During breakfast, lunch, and dinner, when I was in the library, I reread Soul on Ice and Angela Davis's books until the guards realized the books were there and removed them. At first, the sisters would come in to ask me legal questions. Then they were banned from the library and replaced by the guards, who sought my opinion about their own legal problems. So I struck a bargain with them, and thereafter, to my amazement, half my time was shared with them and half with the inmates. When the guards learned I was Joanne Chesimard's lawyer, their search for free legal advice did not abate. When the sisters asked me if I was Asada's lawyer, they asked from the side, slipping the question in between deals in a card game, pretending no real interest, but just as an item of possibility, was I? We had a good relationship, and that information neither lessened nor enhanced it. They had read the newspapers but didn't really understand what Asada was all about, except that she was a bad sister and... Right on. Most of the afternoons, between lunch and dinner, we played cards, spades, and hearts. I'm a great poker player and had spent many 3-day weekends in poker games with friends. So I learned the other games quickly, and the highlight of my incarceration happened when Hazel, the most reluctant to accept me, noisily claimed me for her steady partner, interrupting my reading or writing in my cell by yelling, "Come on out. The game is starting." They made large jars of Kool-Aid to drink during the games, especially for me, so that I would have some nourishment. I became their project and they protected me, frequently offering to push my mop because they felt I might be getting too weak. I didn't feel weak at all, as a matter of fact, until the day I was released, and for about 4 days afterward, I no longer felt any hunger. I drank gallons of water and would have taken vitamins, a daily pre-jail habit, were it not for the fact that I didn't trust the officials. They might have given me anything and called it a vitamin. One of the most annoying aspects of prison life is the nomenclature used by the corrections people. Ladies, time for medication was a euphemism for the tranquilizers given out 3 times a day when the sisters lined up in eager anticipation before the pill-laden carts. It was always, ladies, lights out. Ladies, time to get up. Ladies, commissary, mail, food time. Now, ladies, behave yourselves. The mother wore a uniform and had total power. The children pouted but silently complied. Only 1 letter a week could be mailed, and despite Supreme Court decisions to the contrary, each one was read by the guards. Visits were restricted to family members or lawyers, so while Doris, B.Y., and my brother-in-law visited, my best friend, Doe Burke, couldn't. Flo Kennedy was an unauthorized surprise and was disappointed that I was too weak to attend the dinner party she had planned for me at a Harlem restaurant upon my release. While Westchester County Jail represented imprisonment under the least brutal conditions afforded the minority poor, perhaps in the entire country, it did not equal the facilities for convicted white-collar criminals or governmentally approved robbers and burglars like the Watergate gang with their tennis courts, golf courses, and swimming pools. But given the repressive nature of confinement itself, at least it was as humane a separation from society as was permitted to those unprivileged among us. Imprisonment is more than isolation from the world. It is confinement in an artificially engineered society with forced associations and supervision of a kind not experienced since childhood. Decisions are wrested from you. When to sleep, when and what to eat, what to read. One radio station fixed in place for you, its dial position to high to be changed. Forced submission to arbitrary authority pervades the smallest detail of your daily movements. The staff is alert to the slightest deviation and is quick to force submission with threats of solitary confinement or the withholding of mail or medication. Only internal flights from prison walls are possible. Dealing with the abrupt separation from your life, adjusting to prison rules and regulations, and resisting a natural instinct to defy senseless, meaningless commands are the most difficult feats to successfully accomplish. When you enter an environment that renders you helpless, not only do you relinquish control of yourself, but your dignity is removed with the removal of your clothing, replaced by prison uniformity, and closeted as your clothing is elsewhere. The hunger strike enabled me to maintain control over what I put into my body and to withstand any possible erosion of my will to resist the daily demands for total submission. But I was there for only 10 days. As I marked each day off on the calendar I had made, I knew that had my sentence been longer, I would have had to find another device for my own survival. The sisters gave me a party the day before I left. They had purchased Kool-Aid and cookies from the commissary and decorated the card table with handmade goodbye cards. I still have Hazel's gift, an attractively bound pink-covered telephone book that Avon handed out to its salespeople. Inside the cover she had written, "To Evelyn Williams. From a friend. Evelyn, it was a pleasure to have you as a short friend. I hope we will see each other again, but not in a place like this. Good luck in your work. Your pal, Hazel. P.S. You are a good cards player." The contempt citation was a criminal misdemeanor, but Gagliardi could have cited me for civil contempt, which would not have been a crime. And had the circumstances in any way justified it, he could have charged me with contempt as a felony, which, regardless of the length of the sentence, would have resulted in automatic disbarment. Instead, he let the Appellate Division of the Supreme Court of the State of New York, First Judicial Department, tie up the loose ends for him. On May 13, 1975, one was served with a petition signed by the Association of the Bar of the City of New York. The Bar Association had been created by an act of the Legislature of New York in 1971 to elevate the standard of integrity, honor, and courtesy in the legal profession, and is the only one of all the bar associations in the city anointed with the responsibility to initiate disbarment proceedings. It is also a bastion for corporate lawyers and large law firms, and since its inception has discouraged minority membership. The petition stated that on or about March 5, 1975, the Executive Committee of the Association of the Bar duly approved the request made by the Committee on Grievances of the Association for authorization to prosecute the respondent without hearings before the said Committee on Grievances. John Bonomi was chief counsel to the Committee on Grievances of the Association. The petition recited the part of the transcript of the Bronx robbery trial that reflected my allegedly offensive conduct, as well as the Court of Appeals decision affirming Gagliardi's order. Among other things, it reiterated the Court of Appeals opinion, which held that Gagliardi had offered Miss Williams the opportunity to purge herself of her contempt, and she had declined. The court asked Miss Williams if she had anything to say in defense of her contumacious conduct, and she stated that she did not consider her conduct contumacious. The Bar Association petition was 52 pages long. I prepared a response and waited for action to be taken against me. I had no way of knowing what to expect, since a hearing in which I could have introduced other evidence had been denied. But disbarment was the action implicitly being sought by the Bar Association, and I was prepared to appeal if that decision was made. In the meantime, I continued my preparation for Asada's cases that were still awaiting trial. But I was fortunate. The presiding justice of the appellate division refused to act on the petition and dismissed it out of hand. His reason was that I was being selectively and prejudicially prosecuted, and he would not permit it. I might add that Justice Harold Stevens, now dead, was also black. I am now associated with Stevens, Hines, and White, the Harlem law firm founded by his brother, Hope Stevens, long a prominent community activist before his death. 6 days after I received notice of the Bar Association's disciplinary action on May 19, 1975, I was almost murdered. The day, Malcolm X's birthday, had started out pleasantly. I had lunch with a young, recently married couple, both of whom had graduated from New York University and had been active in the Martin Luther King Center and were part of the defense committee for Sundiata and Asada. They were expecting their first child, and the conversation centered on their preparations, their jobs, and their plans to leave the city to better raise their child. I was relaxed, pleased to see the young, happy with life faces charting their lives with the confidence and fearlessness vested in the young. Apart from a few such pleasant interludes, I was always preparing for Asada's remaining cases. I still did not know the order in which the cases would be tried, although I had expended every effort to find out. But in 2 cases, the Queens Bank robbery case to be held in the Eastern District Federal Court and the drug dealer murder case to be held in the Kings County Supreme Court, one of Asada's co-defendants was Andrew Jackson. And Robert Bloom was his lawyer in both. While I believed Asada's trial should be severed from Jackson's in each case, she rejected that plan and continued in her firm position that unity among the co-defendants must be maintained. But there had been no joint conferences between Asada and Jackson, although rhyme motion for such a conference had been allowed. I felt that only a convenient time for the meeting had to be arranged. Despite my reluctance, I left several messages at Bloom's office asking him to call me to set a time. When he didn't return my calls, I wrote to him, but he still did not reply. What I didn't know was that there was a very logical reason for Bloom's refusal to discuss joint trial strategy. His strategy had already been put in place. Unknown to everyone except the U.S. Attorney, the judge for the federal court in the Eastern District, and Bloom, Jackson had already pleaded guilty to the indictment and, in a sealed statement made at the time of his plea, had identified Asada as one of the bank robbers and promised to testify against her at the trial in exchange for the government's promise of leniency. While the former students and I were dawdling over coffee at lunch that day, Martha Pitts, also a former member of the Martin Luther King Center at New York University and a member of Asada's cell, a defense committee formed to protest her jail conditions, came into the restaurant. I had not expected to see her but was agreeably surprised. Martha was a registered nurse, and her medical knowledge had been invaluable in helping me understand the shorthand nomenclature of hospital records and coroner's reports. I mentioned the difficulty I were having trying to reach Bloom and said I needed to know when he would be available for a joint conference. I knew he was in the Bronx Supreme Court on trial with Victor Cumberbatch, but I had been reluctant to make the trip there or to have to talk to him. When Martha offered to go there with me, right then, I welcomed her suggestion and we left the restaurant and took the train to the Bronx. We walked into the courtroom in which the trial was being held before Judge Ivan Warner, and the court officer immediately waved us out. We left, but since courtrooms are always open forums, I wanted to know why we were prevented from entering even as spectator members of the public. The only time courtrooms are closed is during the judge's charge to the jury before the case is given to them for their deliberations. And even then, all those who are seated before the charge begins are allowed to remain. On such occasions, the door to the courtroom is locked and a sign posted saying, "Jury is being charged." I opened the door and motioned for the court officer, a tall, heavy black man whose name I later learned was Augustus Argret, to come into the corridor. He did so, explaining that no one was permitted into the courtroom because the jury was being selected. I asked, really knowing differently, whether it was a proceeding whereby the public was excluded. He said it wasn't, but explained that the judge did not want spectators sitting alongside potential jurors. I had noticed when I had entered the large courtroom that there were only a few people there, and I remember comparing the sparse attendance with that at Asada's trials, where supporters not only filled the courtroom but lined the halls waiting for a vacated seat. I mentioned that there were plenty of spaces in which we could sit and be far removed from any of the potential jurors, leaning against the wall next to the courtroom as I talked, conversational, really quite happy that circumstances beyond my control prevented me from contact. At least on that day, with Bloom. I told him that I was a lawyer and asked him if he would give Bloom a note from me, explaining that I had to arrange a joint conference with him and my client on another case, Joanne Chesimert. He looked at my note, written on the back of one of my cards, and without warning, lunged at me. Both his hands tightened around my neck, and he wrestled me backward by the throat to the end of the corridor. The fury of his attack was like a tornado. Sudden and deadly. All I could do was scream. My off-guard, off-balance movement backward permitted no other response. But my screams were sufficiently compelling to alert every courtroom on the floor from which court officers poured. Collectively, they pulled him away from me. Once we were separated, to my amazement, he again approached me, forced my arms behind my back, handcuffed me, and said, "You're under arrest." The court officers surrounding me talked to him, trying to dissuade him. But he was adamant, pushing them away with the same force he had used on me, sending one smashing against the wall. He was completely out of control and dangerous to everyone. And the court officers, unsuccessful in their appeals to him and fearful of his massive, unleashed rage, stepped away. I could use many adjectives to describe him and his actions, but none would be adequate. By the time I was brought from the holding pen in the courthouse to 2 other police stations, terminating at the 42nd precinct, chained and shackled to other prisoners, it was about 6:00 p.m. My neck was swollen to 3 times its normal size, and I could not speak. There was a loud ringing in my ears, which persisted over the next several days and which my doctor told me was caused by the pressure exerted on my neck. Both my wrists were sprained, and black and blue colorations surrounded the large lumps on both my arms. My chest was scratched, and the jacket to the gray suit I was wearing was ripped. The handle of my pocketbook was torn off, and my briefcase was missing. Fortunately, because I had not planned to do any legal work that day, it contained nothing of significance. At no time was I told why I was being arrested or the nature of the charges against me. I was refused a telephone call as well as medical attention, which I repeatedly requested. Mug shots and fingerprints were taken at both precincts. My right hand was so swollen and stiff that the police officer at the 42nd acknowledged, as he tried to move my ink-stained fingers across the fingerprint sheet, that the injury was apparent to him. But the complete horror of the drama was still to be unreeled. I was strip searched at both precincts, but the search conducted at the 42nd precinct by police officer Canby, a white woman, was the most vicious and most humiliating I had experienced. It was held in the filthiest bathroom I had ever seen in my life, the floor covered with excrement, alive with a nauseating odor. When Canby completed the search, she returned my clothes to me. But before she gave me the slacks to the pantsuit I was wearing, she held them up to my face, then dropped them and stepped on them, mashing them into the floor. I looked at her for a long time, knowing I would never forget that face. Afterward, before I was put into the cell in which one spent the night, every scrap of paper in my wallet and pocketbook was removed and examined by Canby. Her reason was that my several credit cards and other identifications might be stolen. The cell contained an uncovered iron bench and a toilet that could not be flushed from the inside but only by the guards from the outside, and there was no toilet paper. To get some, it was necessary to ask the guards, and they refused either to give me toilet paper or to flush the toilet in my cell. No food or water was offered, and no pillows, sheets, or blanket were given to me. At 11:30 p.m., I was told that I would not be arraigned until the morning and to enjoy my stay. I spent the night sitting on the edge of the bench in my underwear, the stained slacks distanced as far away from me as I could place them. I was disoriented because, along with the belt to my jacket and shoelaces, they had taken my glasses and I could see little in the gray dimness, not even the filth on the walls and floor of the cell. I gently felt my cricoid cartilage and remembered how easily death is caused by its fracture. Martha Pitts, also arrested with me but not in any way touched by Argret, was in the cell across from me. She tried to converse, but I couldn't answer. And anyway, my pain and fury were too great to have communicated even with God. I smoked cigarette after cigarette, which, strangely enough, had not been taken. By 8:00 a.m., when all the cell doors opened just prior to bringing the prisoners to arraignment court, the entire area was filled with the smothering stench of excrement and unwashed bodies. There were about 9 women in addition to Martha and me who had been there for the night. One white woman was courteously given medical attention for a severe headache. My requests had been ignored. There was no water to wash my face or rinse out my mouth. There was no mirror to adjust my hair or in any way smooth out my appearance to be somewhat presentable before the court. Disheveled, my clothes smelling from the residue of the bathroom floor, ragged, exhausted, and in pain, I was taken to the courthouse again in a police van and again shackled to the other prisoners. It was only in the courtroom that I learned of the charge against me. It was a felony complaint, assault in the 2nd degree, under the following circumstances. Deponent Argret states that at the above time and location, the defendants together and acting in concert did accost a juror and did scream and attempt to forcibly enter the courtroom and when refused admittance. The defendants did intentionally cause deponent physical injury by struggling with him and kicking him in the shins. Deponent further states necessary force was used to effectuate the defendant's arrest. I was, of course, surprised that Martha had been arrested along with me, but that the complaint against us was identical defied credulity. I remember seeing her as I was being throttled down the hall, leaning against the wall of the corridor in what appeared to me to be a rather casual posture, considering the circumstances. In any event, I represented both her and myself and was barely able to talk to either the assistant district attorney or the judge, both of whom looked at the felony complaint and barely concealed their disbelief. On application of the district attorney, the complaints were dismissed immediately and without a hearing. I had called Doe that morning, and she picked me up from the courthouse and drove me home, where I scrubbed and went to my doctor, who referred me to a throat specialist. I stayed home for a week, healing, and did not need a medical evaluation to know that I was indeed lucky to have survived. Chapter 15. A presiding judge establishes the emotional climate that shapes a trial and influences the attitude of jurors, the conduct of defense and prosecution lawyers, as well as the behavior of defendants. Judge William Thompson was the trial judge in the Brooklyn Supreme Court on September 6, 1975, when the drug dealer kidnapping case began. He was an energetic black man in his early 50s who power walked around the courtroom whenever his presence on the bench was not required, his long black robe flying behind him in the wind of his energy. He barked orders to the court attendants and ruled the courtroom with both humor and authority. Throughout the long 4.5-month trial, his unflagging, upbeat personality charged the atmosphere, filling it with his crisp decisions delivered in the well-defined enunciation of a native New Yorker, and despite any preconceptions he might have had, he was always even-handed and legally substantive, whether he ruled for or against the defense. Judge Thompson is now a justice of the Appellate Division of the Supreme Court of the State of New York. Assata, Melvin Kearney, and Ronald Myers were charged with kidnapping a drug dealer from a bar in the Bedford-Stuyvesant section of Brooklyn, drugging him and demanding ransom for his release. Ronald Myers was a tall, thin, graceful, somber, employed 19-year-old who was as innocent of political activity as he was of the charges. When the indictment was announced in the media, he obligingly surrendered, never doubting that the mistake would be corrected and he would be released. To his disbelief, he was sent to jail for 2 years before his medium-income family was able to post the enormous bail that had been set. His lawyer, James Carroll, was outraged, and while our relationship was cordial, he clearly preferred to distance himself from Assata and me. I understood the strain under which he was functioning and sympathized with his position. He was a novice lawyer, a friend of Ronald's family, and it was the first time he had been involved in a case of this negative political dimension representing a client whom he believed to be completely innocent. I shared the results of my investigation with him and did not intrude on his well-justified anger. Melvin Kearney, a muscular young Black Panther, full of laughing disregard for the system, died while attempting to escape from the Brooklyn house of detention a few days before the trial began, when the rope he used to lower himself from the 8th floor broke. The news was traumatic, staining the beginning proceedings with its tragedy and forcing hurried adjustments in strategy. In New York state courts, lawyers conduct their voir dire of prospective jurors, and this lengthy trial was equally divided between jury selection and the trial itself. There are several obvious advantages of lawyers conducting the voir dire. A lawyer can flush out suppressed attitudes and biases by instant follow-up questions rather than waiting for the judge to ask them after he or she completes the first interrogatories. The tone of a lawyer is completely different from that of a judge, particularly a prosecution-oriented one who will try to rehabilitate a juror's bias or already established opinion. Additionally, a trial lawyer is able to respond to a juror's mood swings, reactions to the defendant, expressions, nervousness, or efforts to control animosity, which the intervening role of the judge dilutes. So I was pleased, at last, to be able to directly speak to jurors, to ask them questions that reflected our defense strategy and also exposed the weakness of the prosecutor's case, thereby preparing the chosen jurors for the evidence to follow. My investigation revealed several surprises. The bar in which the kidnapping allegedly occurred was not owned by the main witness for the prosecution, was operating illegally, and was managed by her boyfriend, the self-described kidnapped drug dealer, who had a long criminal record. His Bureau of Criminal Investigation sheet reported convictions but no sentences, a red flag to the possibility that he had cooperated with the police or the FBI. In light of the just-released Church Committee COINTELPRO report, I suspected that he was either a paid informant or an actual agent for the FBI, and to introduce this element into the consciousness of the jurors, I asked each of them whether they could give the same degree of credibility to him as to any other witness were it revealed that he was an FBI informant. It was the prosecutor's heated objection to this question, stating that there was nothing to indicate an FBI relationship with any of the prosecution's witnesses, that alerted the jurors to the significance of such a link. The objection was overruled, and by the end of the voir dire the jurors chosen, each of whom had been seated in either the courtroom or in the jury box during the voir dire of other prospective jurors, had heard this question over and over again and were well aware that this malevolent possibility could arise during the trial. When it did, the prosecutor was trapped by his protests and appeared to have been intentionally concealing information that he was legally obligated to reveal to the defense once the witness was put on the stand. Except in the case of an affirmative defense, such as insanity, alibi, or self-defense when the defendant has the burden of proof and is compelled to take the stand. The defense must shred the prosecution's case to prevent him from establishing guilt beyond a reasonable doubt through either cross-examination or introduction of evidence to rebut the prosecution witnesses. Our motion for Assata to act as co-counsel was granted, and elegant in a long, colorful African dress, she delivered the opening statement, outlining the philosophy of the BLA and its response to the injustices dealt to Black Americans, and asking the jury to judge her solely on the issue of guilt or innocence of this particular crime and not by her admitted association with the BLA. The testimony of the bar owner that she was licensed by the State Liquor Authority and the Alcoholic Beverages Commission to operate the bar was discredited by subpoenaed records and witnesses from both agencies, which revealed that she had never been issued a liquor license, and by the real owner of the bar, who testified that he did not know her and denied giving her permission to operate the bar, which he said he had closed. Subpoenaed Kings County Hospital records of the drug dealer, who testified that he had struggled out of hand and leg cuffs and made his way to the emergency ward to have his stomach pumped. Proved not only that his body contained no drugs except a trace of cocaine, but also that when he entered the hospital he did not report he had been kidnapped. And under Carroll's cross-examination, the drug dealer admitted that he was in fact a paid FBI informant, but he invoked his Fifth Amendment right and refused to testify further. And when his identification of Assata as being present in the bar became less than certain, the prosecutor called a cross-eyed witness with obviously defective vision to testify that he had seen Assata in the bar on numerous occasions, including the night of the kidnapping. To buttress his identification, he said that she had spent several weekends at his house. I could not resist asking him a ridiculously dramatic but dangerous question most frequently interjected into B-movie criminal trials. What is the color of her eyes? I ended my cross-examination when he said he didn't know. Desperate by now, the prosecutor moved to admit into evidence all of the weapons recovered on the New Jersey Turnpike that had been introduced at Sundiata's trial, as well as other papers and documents found in the Pontiac that had not been introduced into evidence. A handwritten note demanding $25,000 ransom, signed Black Liberation Army, had allegedly been left at the bar, and I had fully expected a pretrial motion for samples of Assata's and Ronald's handwriting to be taken. None had been made, and I supposed that the prosecution intended to make a comparison of the writing on the note with some handwritten materials that had been found in the trunk of the Pontiac. These items were clearly inadmissible at this juncture of the trial without proven connections to either Assata or Ronald, and both motions were denied. I made the briefest summation of my career, and the jury took just 8 hours to return a verdict of not guilty. The trial ended on December 16, 1975, and Assata was ordered to proceed to trial in the Queens bank robbery case on January 6, 1976, before the U.S. District Court for the Eastern District. This was the case in which Judge Mishler had been removed after ordering the vicious photographing session of Assata by U.S. Marshals. By now, not only my own resources, but those of Doris and Doe, who had amply supplemented my efforts, had dwindled, and I had been forced to accept a few cases simply to pay my bills. One trial had been postponed for the umpteenth time, and once Assata's Brooklyn trial ended, I was directed to begin my other trial immediately. When Jack Weinstein, the judge who had replaced Mishler, refused to grant an adjournment of the Queens bank robbery case, it was necessary for Assata to find another lawyer. Stanley Cohen was recommended by one of the defense committees who had visited Assata while she was on Rikers Island, and Afeni Shaker, a defense committee member and a professional paralegal, was given permission to sit at counsel table as Cohen's legal assistant. Unlike Mishler, Weinstein was a thoughtful judge who voiced no anticipation that Assata would disrupt the court as Mishler had predicted, and was impervious to her political associations. He expressed judicial concern about the violation of her constitutional rights when the photos that had been taken at Mishler's orders were shown to him. And he conducted the trial with the dignity and legally balanced acumen that anyone charged with a crime in this society has the constitutional right to expect. He repeated his impartiality, stating, "My sole interest is to see that the case is fairly tried. The evidence linking Assata to the crime was the bank surveillance photographs, the identifications made by the bank tellers at the time of the robbery, and Andrew Jackson's statement that Assata was a participant made at the time he pleaded guilty to the indictment in exchange for a favorable sentence." Stanley Cohen's first motion was to ask for a subpoena for Jackson to testify at the trial, advising Weinstein that he had spoken to Jackson a few days before the trial began and that Jackson had recanted his statement, alleging that he had been coerced into making it by the assistant U.S. attorney, who had refused to accept his plea unless he implicated Assata. But Stanley's masterstroke was to also subpoena Robert Bloom, Jackson's attorney, who was present along with the assistant U.S. attorney at the time Jackson pleaded, to testify about the conditions under which the plea had been given. Once entered into the record, the plea bargain had been sealed, hidden from the defense, and would not have been disclosed until after Jackson's trial testimony. Stanley further advised Weinstein that Jackson would also testify that Assata was innocent of having taken part in the bank robbery. Stunned that the sealed conditions of the plea had been discovered and faced with Stanley's threat to publicly expose his complicity in framing Assata, Bloom quickly admitted to Weinstein that Jackson had been forced into making the plea, but asked that he be permitted to stipulate that fact on the record rather than testify about it in open court before the jury, claiming that he planned to go on vacation to Mexico and California the next day. Weinstein nevertheless ordered him to remain in the state and to be available to the defense as its witness. Bloom's testimony was not required, however, because Jackson refused to take the stand against Assata and his statement became a non-issue. The prosecution's repeated efforts to introduce the Mishler photos were rejected by Weinstein, who said, "I have told you, you may not use that photograph while it shows all those hands and people holding the defendant down." The prosecutor's alleged purpose in displaying the photos to the jury was to prove that Assata had resisted the comparison poses. Her avoidance, he would allege, inferred guilt. Assata countered in her opening statement to the jury that she had refused to be forcibly posed or to have her appearance artificially altered to resemble a bank robber and that she was innocent of the charges. The bank employees present during the robbery who had identified Assata as a participant to the FB admitted that the only photo they had been shown was a mugshot with the words New York Police printed across her chest and the Bureau of Criminal Investigation serial numbers, an illegally suggestive procedure designed to classify her as a criminal. It was a most potent device when none of the other photos were so defiled. Other tellers could not identify Assata, and the prosecution's main witness, the head teller who had been specially trained to identify bank robbers, after stating he was positive that Assata was the bank robber, admitted under Stanley's caustic, penetrating, and persistent cross-examination that she resembled the bank robber. The trial transcript records the following questions and answers. Stanley, have you ever been told that you resemble someone on TV? Teller, yes. Stanley, whom have you been told you resemble? Teller, Robert Stack. Stanley, are you Robert Stack? Teller, no. Devastated, the teller finally answered yes to Stanley's question. So, in all fairness, you would have to say the possibility exists that you might be mistaken? At which point Stanley said, "Thank you. I have no further questions." Assata was acquitted on January 16, 1976, after the prosecution's FBI photographic expert admitted that, even after using the most recently developed computer comparison equipment, he could not prove that the person in the surveillance photo was Assata. And on that same day, Assata was returned to the state of New Jersey to stand trial for the third time in the Turnpike case.
Catherine Massey Book Club, Context of White Supremacy. We'll pick up on Chapter 16 at the very beginning. Not for spectators. Folks have thoughts, questions, observations from the first chunk of audio. The number to dial 720 716-7300. The code 564-943 pound. Press star 61 if you would like to participate. Number again, 720-716-7300. The code 564-943 pound. Press star 61 if you would like to participate. Before we get to the text, first portion, man, they have an exhibit at the University of Washington, Seattle campus. Right now, it's at the Suzalo Allen Library. It's public, and it's called, I think it's Banned Books or something somewhat similar to like Banned Books, but it goes into detail and talks about different regions where books have been banned and the history of book banning and many, many different books that have been banned, and goes into reasons why they were banned and time periods and all that. There are a number of books that we have read in the Catherine Massey Book Club over the years that popped up in their exhibit on banned books. Like I guess one, Counter Racism is Subversive. I did not know that the Catherine Massey Book Club, in addition to being counter-racism subversive, that we pick or have picked a lot of books that have been banned for a variety of different reasons. And I mean quite a few. Like I was surprised, like as I was kind of walking and looking at the exhibit, like, oh, there's Bluest Eye, and oh, there's another. Anyway, if it had been maybe better times on the plantation, I would have actually stopped to take lots of pictures, because man, there are quite a few, and I mean over a long period of time, not just some of the recent ones, like going all the way back to the very beginning and then all the way up to current books that we have. Even though this book is not on that list, I suspect this is the type of book that would be a banned book. Like I don't know if you could show up to Newark Public School and say, for Black History Month, we're going to read Evelyn Williams' Inadmissible Evidence in your middle school. Like, I don't know. Anyway, let's see. Number again, 720-716-7300. The code 564-943 pound. Press star 61 if you would like to participate. Don't wait till we get to the second audio segment to get a hand up. I will say quickly, the audio that I played from the documentary Movement Lawyers with all those white attorneys, Bob Bloom, now he was mentioned before, where she had already, I told you that was what motivated me to go watch that documentary, was that he was mentioned previously, and Miss Williams said, I'm kind of suspicious, you got all these white attorneys, Mr. Bloom included. He's not the one that adopted the Negro children, but still. And she's like, I'm a little bit suspicious, like, what are they doing? And she told us how difficult it was for her to do this work. Like, she's struggling and sacrificing her health and getting arrested and almost choked out and everything to do all this work. Like, how are all these white people who say that they are not racist, how are they, just all in to work on all these cases? And what's going on here? She said she was suspicious, and then you hear more details this week. Like, oh man, I'm ready to go back and watch that documentary again, like just to see. And even, is Mr. Bloom, is he still with us? Is he still alive? Maybe we can, chat it up. That would be interesting. Any hoodles, I'll do one email as we are seeing if folks have thoughts. Let's see. Email 1. Greetings, Gus, listeners, callers. Rikers Island is 413 acres in East River in the Bronx, New York. It is named after Dutch settler Abraham Riken, who took possession in 1664. His descendants' name changed to Riker. Is that, what do they call it? How you Anglicanize your name? You heard that? Is that what that is? Or no? Anyway, Abraham Riken. Richard Riker, or name changed to Riker, owned it until 1884 when it was sold to New York City for $180,000. The most famous descendant was Richard Riker. During the 19th century, he was the New York City recorder who managed the criminal courts. He was outed by abolitionists as a member of the kidnapping club. In his position, he ran a racket in which he would prosecute free black people without cause or due process and have them transported south to be sold into slavery. Hey, 12 years of slavery, read about that one. Consists of 10 separate jails. Current inmate population, 7,067 as of 2025. At its peak, it held nearly 19,000. Jesus Christ. Privileged black dudes. 85% of inmates are listed as black or Hispanic, so-called. I could not find any information that broke down the demographics further, unfortunately, given all the confusion surrounding what Hispanic means. Deliberate confusion. Chapter 13, October 31, 1974, Judge Peter T. Farrell motioned to dismiss the case. Dismissed evidence was paper thin. Farrell died at age 92. He presided over the 1952 case of bank robber suspected racist Willie Sutton, who was sentenced to 30 to 120 years. Sutton reportedly was asked, "Why do you rob banks?" And he replied, "Because that's where the money is." This phrase became known as Sutton's Law and has been used in U.S. medical education as a metaphor for looking for the most likely cause when making a diagnosis in a patient. Sutton denied ever saying this and blamed it on a reporter who made it up. That could be true. Sutton reportedly said he thought it ironic that such a pithy comment be used as an instrument for teaching medicine. 2. 131 to 132, December 11th, 1974, Judge Jacob Mishler, Asada submit to the photograph by agents of the Federal Bureau of Investigation. Sounds kind of ice. Judge Mishler refused. Aura of a Nazi concentration camp. This time the commander was a Jew. An example why we should not disaggregate suspected racists into groups. Why would that be? You're saying we should not pick up the so-called Jew? Is that it? I got it. Is that it? No calling white people Jew and all that. I gotcha. It took me a moment. I'm a little slow, but I got it. My brain computer was also, I thought of Neely Fuller Jr. when in this section, where she said in metaphors, this time the commander was a Jew, whatever that means. I immediately thought, hey, Fuller talked all the time that the Nazis during World War II, they employed so-called Jews, the very people that they are reported to have stuffed into ovens by the millions. They had the Sounder Commando, and they have whole books and documentaries and newspaper articles and all that. I think one of the last surviving members of the Sounder Commando died within like the last 15 to 20 years or so, and they had a big report in the New York Times about all this. But the same thing where they might get a black person and make them the overseer on a plantation. Nazis did the same thing. They did take some Jews and put them in charge, even at the concentration camps. And if you don't want to do it, no problem. So, and she said this time the commander was Jew. I said their very name was Sounder Commando. You can look this up. I never heard about this until I heard it from Mr. Fuller, but that's not even historically accurate. That yes, you did have so-called Jewish commanders right there lead, and I think they have books and stuff about this where they had to put their cousins and such in the ovens. Same thing we've heard before. We get a black person, Fannie Lou Hamer, she talked about how they would get a black dude's privilege to go and beat her down in Mississippi prisons, and it would be the same thing. If you don't want to do it, Leroy, we'll just put you in greater confinement, Khalif Browder style, and we'll get another nigger to do it. No problem. We got bunches of them in Parchment. No problem. Come here, Devontae. Ask you one time, too. Not going to give you no time to think about it if you want to beat Fannie Lou Hamer or not. Next. Mishler continued to manifest bias. In other words, practice racism, white supremacy. Facts. I said the same thing when I read bias. Like, I do not use that term. Not when I mean practice white supremacy. No, I don't use bias. Page 133, U.S. Marshals, arm around her throat. Assault continued, a melee on the floor. Take any force that is necessary. The brutality that this tiny woman endured, female, at the hands of race soldiers is astonishing. Moreover, it was in full public view. That's what white power looks like. I can only say, like, during this time period, they have so many trials and such, where black people, and this is not the police, this is not Fannie Lou Hamer, what I just said. I'm talking about, in court, of guards, got some black person in a headlock. That is so, I told you last week, they got pictures, Bobby Seale, same thing that they said about Assata, where they got him shackled and gagged and bound. It's so many during this time period, just went on and on. It probably got some of this now as well. Although I saw No Count Max Anderson, they didn't do all that. In fact, I looked at the archives. They didn't do all that to Jeff Dahmer either. Just saying. Let's see. 5. Judge Mishler's removal. January 5, 1976, Judge Jack Weinstein. Weinstein died at age 99. That is what white power looks like. You don't die at age 50. Marshawn Nealon at 24. No. 99 years to practice racism. My man Strom Thurmond, he lived to be 101. Mishler, identified as so-called Jewish, he worked for the NAACP Legal Defense Fund and was a member of the legal team working on Brown v. Board of Education. Hey. Not all white people are racist. Mishler downplayed his contribution, saying his contributions were on the level of a young associate preparing briefs and research. Aw, shucks, get out of here. Chapter 14. Judge Gagliardi held me in contempt. Courtroom, 10-day prison sentence. William Kunstler, late, I believe. O.T.Wells, National Bar Association. Haywood Burns, National Conference of Black Lawyers. Arthur Kanoy, Center for Constitutional Rights. William Kunstler, suspected racist, controversial, peripatetic civil rights lawyer. I recall he was continually in the news giving news conferences regarding his defense works for various left-wing radicals. He died 1995 at the age of 76. I thought he had passed away. Some of his clients included Revolutionary Communist Party, Mississippi Freedom Riders, Black Panther Party, Weather Underground, Chicago 7, Attica Prisoner Rebellion, American Indian Movement, MLK, Wayne Williams, H. Rap Brown, Jalil Alamin, new name, Adam Clayton Powell Jr., Angela Davis, Mumia Abu-Jamal. O.T. Wells died age 87. Noted civil rights attorney. Actually, William Kunstler might be in that group of white attorneys, too. Playing both sides. Racist suspect. I lost my place. O.T. Wells died at age 87. Noted civil rights attorney. Clients included Harlem gangster Ellsworth Bumpy Johnson, H. Rap Brown, again, Jalil Alamin. Congress of Racial Equality Corps, see Harlem World. O.T. Wells, Harlem's renowned civil rights attorney and Watergate advisor, has died. Haywood Burns died age 56. At age 15, he organized a successful campaign to integrate a public pool in his hometown. I know they tried to bomb and kill him. Served on the MLK Poor People's Campaign, defended Angela Davis, assisted Nelson Mandela in writing South Africa's interim constitution. He died in a car accident in Cape Town, South Africa. Drive kind of dangerous. Arthur Kanoy, suspected racist, identified as Jewish, was part of the defense team for Julius and Ethel Rosenberg. We just read about them, I think. Defended suspected racist organization, Students for a Democratic Society. Miss Williams was talking about her work. Yeah, okay. Foster care work and all that. 2. her hunger strike. She purchased only candy bars from the guards. That's how she does it. She gives it to us. She would write daily notes. Blacks were most of the women in the facility. Used my legal knowledge to write letters. Perhaps an example of codification, attempting to turn a non-constructive experience into a constructive one. Hey, seems race soldiers give many individuals classified as black that opportunity. We're going to see if you can make lemonade out of the lemons of what I just said. Parchment. Angola. Rikers. We got a bunch of them. Joliet. Ain't that the one for Illinois? We throw a whole lot of black dudes up there in Joliet. Let's see. 3. Soul on Ice. Angela Davis books. Guards realized the books were there and removed them. The guards sought my opinion about their legal problems. When they learned that I was Joanne Chesimard's lawyer, their search for free legal advice did not abate. Reading is more important than watching television. Maybe not watching documentaries. Just joking. Simply amazing. I wonder if these correctional officers were white or not white. I do know there were a lot of non-white correctional officers in Rikers Island during the 1970s and 80s. I think white people still employ a lot of non-white people in these types of positions, correctional officers and such. So even trying to recruit them for ICE facilities. So could have been non-white people. I will be truthful. When we read this, the first thing that came to my mind, Jim Jones, remember? When they got to California, this is before they even got to Guyana, they would get them in the concentration camp up in California, Mendocino County, and that would be a part of the brain trashing. We isolate you from everybody. You can't call nobody, can't talk to nobody. We control where you go, what food you get in there, take all the books from you. And I said, whoa, I ain't never heard of that. Put you in an environment, they start stealing books from you. Bang, I've heard maybe this is standard operating procedure in prisons. Now, I know they control what books you get. I do remember saying that, but I'd never heard of if you already have possession of these books and it's up, you got to take that, you can't have that, got to have that. Where did you get medical apartheid? Whoop, can't have that. Code book, nope, can't have. I know in prison, no, you cannot have no code book, can't have no ISIS papers, no manna, might get rowdy, get ID. You probably can't have no soul on ice, get on out of here. Angela Davis, we'll take that, give me that, no. Give you the hate you give, see. That was on the subversive book list. But yeah, that's what I thought was Jim Jones. That's how now, they got TV. I think they said they had the radio. I think they had the TV, and especially now, I know they got TV. Books, whoa, you don't have budget for everything. Write that down. Who said they wanted books? Can you read? Write that down. We got to keep an eye on you, boy. I put you in solid. Got a reading nigger here. Mess everything up we got here. Let's see. 4, we played cards. See, they let you have playing cards. They don't have no problem with that. I've never heard a prison where they say, I want you to think about that because I highlighted that. She said, I just smoke cigarettes all the time. You got a light, man? You got a light, man? She said, I just smoke cigarettes all the time. I just smoke cigarettes. She said, I was surprised they let me have cigarettes. And apparently let me have a bounty of cigarettes. I can't have no books. I can't make a phone call. I can't even get clothes. I just get all the Newports I want. That right there ought to tell me something like, oh yeah, that moron, sobriety would be best. Like, wait a minute now, anything white people, oh yeah, I'll take it all, cigarettes you need, it's no problem. No, can I get a glass of water? Whoa. Wait a minute. Can I get a slice of toilet paper? Whoa, you getting uppity now. Wait a minute. Whoa. But you could do, you puff all day long. Ain't that strange? Ain't that, out of all the things that you can just have, she didn't even say that they charged her. You can get them for free? How about, can I buy a slice of toilet paper? How about that? Forget the cigarette. What do we really need? Cancer stick. Toilet paper. I guess if they're gonna starve you, you don't need the toilet paper, so that might not be. It might not be as much a need. You still don't need the cigarette, even if you're not gonna eat. If you're just gonna drink water, maybe you get 2 slices of toilet paper just in case you need to blow your nose or whatever. Let's see. The books get stolen. We played cards, spades, hearts, and I'm a great poker player. I'm not sure if card playing is the most constructive use of time and energy. Talk about, now see, you can't have a book club, see, because we took all the books, see. But we could sit around all day long playing cards, spades. No, we could sit around all day long. Spades. Got the big joker. Leroy, you the big joker. And we just sit there and wasted 5 hours. Now, we could have talked about legal cases, and you really worked for Asada, and we could have had a book club. They stole all the books. We smoke cigarettes. We sit around, we smoke. And so that, you see, they do that. Come on. Ladies, time for medication. Tranquilizers. C.O.W.S. Book Club selection, Medical Apartheid by Harriet A. Washington. And the text Protest Psychosis, How Schizophrenia Became a Black Disease by racist suspect Jonathan Metzl. 6. Artificial Engineered Society Force Association and Supervision of a Kind Not Experienced Since Childhood. Artificially engineered is an interesting description. Are not all societies, institutions engineered by humans? Yes. Seems like he's comparing prison to childhood in some respects. I mean, it's kind of infantilizing. Yes, you certainly are not a man or a woman in prison. Like she said, you don't even get to decide if you get to wear clothes or not, You don't get to decide if you eat or not. You don't get to, she said all of your decisions are taken away. So it is very much infantilizing. Yes? You don't even have a name anyway. They just give you a number. You don't get to decide nothing. They tell you when to go to bed. It's very infantilizing. Yes? Let's see. Question. That wasn't a question though. Let's see. 7. Contumacious, especially of a defendant's behavior, stubbornly or willfully disobedient to authority. Obstreperous, noisy, difficult to control. These are probably terms that are used frequently in a penitentiary context. People who study what they call legal justice and all of that, I suspect they probably use these terms frequently, especially when discussing privileged black males and Asada. Let's see. Justice Harold Stevens associated with Stevens, Hines, White, Hope, Stevens, Inc., non-white, black dude, privileged, died in 1990, was age 83, impressive, born in South Carolina, even more impressive, served as counsel to the Brotherhood of Sleeping Car Porters, Philip A. Randolph, World War II veteran. He was a first black in many respects, graduate of Boston College Law School, appointed to the New York Court of Appeals. He would be under attack just like Letitia James if he was still there now. 9. Court officer Augustus Argett. He looked at me, lunged hands around my neck, fury of the attack like a tornado. Simile. Strip searched again. Haven't we heard that before? Seems like she's been strip searched a bunch of times in this book, and she's not even the defendant. Police officer Canby, white woman. The floor was covered in excrement. Martha Pitts also was arrested. Felony complaint. Accosted a juror. Attempted to forcibly enter the courtroom. Complaints were dismissed. Was Argett's attack spontaneous? Question. Trying to gain favor with suspected racists? Question. Police, prosecutors, judge. Asada, though thought highly of Miss Pitts, she provided a lot of assistance to her. See Martha Pitts, Remembering a Revolutionary by Assata Shakur. It's on the AssataShakur.org website. How about that? That I don't know. I don't know. He certainly could have been under orders, and it could have been a thing since, he didn't lunge out and strike her immediately, like there was some sort of dialogue about, it's closed, it's not closed, blah, blah, blah. Like it seemed like at any point before she gave him that card with her name on it, she could have, whatever. Oh, okay, it's closed. Oh, okay, thanks for letting me know. She could have walked away, and that would have been that. It wouldn't have been any sort of physical attack, and whatever. He closed the door. They go about their morning. It seems like that could have happened, but once he was able to identify, like, you are that, he totally could have been under orders. Like, if she, and we got the whole setup already that, she tried, because we saw her. And so we closed the door. So we'll just say that she tried to burst in. She attacked you. You felt threatened. She was holding a gun. Maybe it was a camera, but whatever. She was holding a weapon. And yeah, choke her down. Maybe even try to kill her. This is the same time frame as Abraham Bolden, remember? And the guy that showed up at his house said, "You want me to get you a gun so we can go deal?" We were like, whoa. He could have tried to kill Mr. Bolden right then. Like, it could have been so easy for her to be killed, which she said it could have been so easy for her to be killed, and they could have just talked it up as, oh, there was disturbance in the courtroom, and she tried to barge her way in. The officer tried to defend himself, and these Panther niggers are crazy, and oh well, died in court. Oh well, big deal. He totally could have been. In fact, the way, if it happened the way as she told us, that he gets this card, sees, oh, it's you, I would tend to think, yeah, he might have been under some. Well, because why this long exchange? Like I said, why this long cordial back and forth? Why wouldn't it have happened sooner? Why would it be once I can identify, like, oh, you're not some random spectator, you're that negra. That's just what anyway. Let's see. Okay, we got that one. Last one I'll get in. Judge William Thompson Black, Justice of Supreme Court of New York, World War II veteran, again, member of the All-Black Regiment Buffalo Soldiers. How about that? The first black state senator from Brooklyn, New York. He died at age 94 in 1998. Like, wow. Bravo. Very impressive. Race soldiers do not intend for us to be hanging out like Neely Fuller Jr. being around here, no 90 years, 95 years, none of that. That's supposed to be for Strom Thurmond and the like, so they can practice racism for many, many decades. Not supposed to be hanging out so you practice counter-racism and help produce justice. We'll pause there. Email untiljustice@gmail.com. The number 720-716-7300. The code 564-943#. Press star 61 if you would like to participate. Let's see. I'll get in a few of my notes. Keep an eye out. See if folks have observations on the first chunk of the reading. Let's see. I had said that Evelyn Williams, I think she's told us repeatedly about being strip searched at various points along the journey of this text thus far, and we still got quite a few chapters to go. We start off with Asada being getting an internal body probe and being beaten. Now, I'm sure they were not super gentle. We're not going to have any ogreish male guards. We'll maybe just get all non-white females, and we'll do this in the most professional and courteous manner. I'm very sure that is not the sort of experience that she got. And again, that's what I mean. Like, you don't even get to control if you have clothes on. You have no control even over the most intimate aspects of your body. So it's very infantilizing and more to be in such an environment where you have control, autonomy over nothing. Not even if you can flush your toilet. Let's see. And then they lied to her, too, about all of this to help coerce this. Let's see. And being in charge of non-white people's time and energy, where Miss Williams, she said she was going to try to go and participate in the Sada's case, but they would not give her a 2-hour adjournment. Judge Mishler said, oh, no. I'm in charge of niggers' time. We decide if you're on or off. We decide if it's quitting time, and I say it's not quitting time. Back to work, nigger. You can't leave, and that's that. White people still in charge. Let's see. Yeah, I flagged that specifically because it reminded me so much when she said the Nazi concentration camp shower rooms invited the unsuspecting Jews of Europe to their death in the gas chambers, but this time the commander of the camp was a Jew. I think very important, if this is someone classified as white, This is just someone classified as white race soldier. But as I said, also, Mr. Fuller, hey, racists, they did have the sounder commando. They all the time will use non-white people to help enforce, maintain, refine the system of white supremacy racism. They have done that for centuries. Let's see. The unruliness of Assata Shakur's hair. We've heard about that a number of times in the book club, where black people's hair, especially if it is not chemically mutilated to be straight, oh man, we might have to beat it. The black man in Brazilian soccer, because we're not talking about females, but that the rebellious Negro hair was talked about repeatedly. We might have to shave, keep a bald head. Like, oh man, you're going to have all that niggerish, kinky hair. Oh my goodness. Let's see. Chapter 14. I thought it was so constructive that Miss Williams, when she was serving her unjust time in greater confinement for contempt, that she wrote and took notes of her experience so she wouldn't be dependent on her memory, and then she could have lots of details about the experience, and the fact that her note-taking was intimidating to the guards. So, this nigger is writing down all the unjust things that we're doing, all the laws we're bringing, criminal activity that we are engaged in. Like, oh man, we about to get in trouble. Ooh. Taking notes. Talk about that on workplace racism all the time. I also thought it was significant that Assata, or Angela Davis, talked about that she read Soul on Ice and she read Angela Davis's books. Angela Davis is reportedly working on a documentary about Assata Shakur. I just saw it this week. I posted about it online, she and others. Let's see. That was nothing that I celebrated or decried, that coming documentary. Let's see. She talked about the facility in Westchester County, the jail where she was at. She said it did not equal the facilities for the convicted white-collar criminals or governmentally approved robbers and burglars like the Watergate gang, with their tennis courts, golf courses, and swimming pools, plural on all of those. So I guess you get some prisons where they don't just have one pool. They can't just have one golf course. Like, oh, no, that would get boring. I might have to serve 2 or 3 years. So I need to switch it up every now and then. I can just have one golf course. You can just swim in the same pool every day. Come on now. Wow. That is where is the pool at for Assata? Did she not get one of the prisons with a pool? She didn't get that? Oh, maybe you think did he get the prison with the pool, golf course? Did he hook him up? No. Let's see. Yeah, she said decisions were wrested from you: where to sleep, when and what to eat, delectable negra, what to read, the radio station. It was fixed in a place for you. Its dial positioned too high to be changed. Man, forced submission to arbitrary authority. Like, just the way that she describes this, very infantilizing and delectable Negro in so many ways. Even that, when she talks about the clothing aspect, that is also a significant aspect of delectable Negro. Like, you don't even have the ability to dress yourself. I mean, maybe they give you clothes, maybe they don't. She has that dramatic scene where the white officer takes her clothes and stomps them into the feces on the ground and what have you, so she has to kind of sit there semi-nude like that. Delectable Negro. And that's so much of the slave type of punishment, to humiliate and denigrate you. Take your clothes, you got to be naked in front of all the other slaves, or to strip your clothes so you can be then beaten and whipped further. Like, that is such long-running aspect of white culture. We're going to take these niggers' clothes, have them buck naked, as they call it, and then, continue on. Let's see. Where she talked about the New York Bar Association and their discouraging, or officially, I guess, the Association of the Bar of the City of New York, them discouraging minority membership. Like, what? How many Negro members do they have now? have to check that out. Like, let's see. I thought it was stunning. She's going through all this and having to go to jail and fight her own case of contempt and all the rest of it. And she's still fighting the good fight for Assata. She's not saying, look here, niece. I don't know what you done got in or what white people you done upset, but you done been way more than I can chew. You gonna have to find another attorney. Plus, you done got uppity with me before, and you got all these racist white attorneys around it. Anyway, it's more than I can deal with, and I got to take care of my own health, and I'm gonna have to talk to you later. Get your mom to, call me later. Like, she could have said that at a number of spots along the ride here, and she soldiered on. Like, wow, just stunning. Let's see. See, now, this is what I said. Now, see, I didn't know I was going to get to see Robert Bloom. I didn't know I already had the documentary where I could sit here and watch this guy. Like, what? What? She says I left several messages at Bloom's office asking him to call me to set a time for our joint meeting. When he didn't return my calls, I wrote to him, but he still did not reply. What I didn't know was that there was a very logical reason for Bloom's refusal to discuss joint trial strategy. His strategy had already been put in place, unknown to everyone except the U.S. Attorney, the judge for the federal court in the Eastern District. Bloom Jackson had already pleaded guilty to the indictment, and in a sealed statement made at this time of his plea had identified Assata as one of the bank robbers. Now that right there is so COINTELPRO. So much of it is what they call divide and conquer. We'll get non-white people in conflict with each other. It's so easy, especially if you get very young non-white people, victims of racism. You can get them in some sort of extra compromised position. We're already vulnerable. Oh, you got criminal charges? Oh, maybe we can help you out with that, Leroy. Maybe you saw Assata in the bank. Maybe you saw her with the bomb at 8:45 p.m. We can help you with those charges. That's so much of it. Getting them, sometimes even getting the person, the informant, to instigate all the criminal activity, and then you turn around and blame all the other folks. Like, this was your idea. Like, you were the one that came and carried on. Like, come on. But that is what white domination looks like. It is so easy. Same thing I said with Sounder Commando. The exact same thing. Neely Fuller Jr., the great. The same thing. That's why he brought that up. That's why he said, resist the urge to be sitting around name calling and criticizing other victims of racism, because it's so easy for racists to just grab any victim of racism. Get over here. You're going to help us on the plantation today. Now, you're going to beat Leroy or whatever. You're going to testify against Assata or whatever it is. It's super, and again, you don't want to do it? No problem. Solitary to you. Get down there with Khalif Browder. We'll come get you out 5 years from now. See if you're still alive. Let's see. Devontae, get over here. You going to testify against Assata? And hey, look here. We'll give you a sandwich if you do it. They got lots of it. We'll give you a pair of britches and a sandwich if you do a good job. They got lots of ways that they can, and I mean lots. Incidentally, that would be another one. United Independent. You gonna rob a bank? That for sure is United Independent. That way ain't no Devontae Leroy to snitch on you, because I didn't do this with Levante and Leroy and all the rest. It was solo, one of one. Ain't nobody to snitch and tell and all that, because I didn't get no team to go rob the bank. Not encouraging bank robbing. Any hoodles. We will pause there. If you have thoughts, observations to share, make a note. We'll have ample time once the second audio segment concludes. We will pick up Chapter 16, Evelyn Williams, Inadmissible Evidence, Catherine Massey Book Club, Audio Segment 2.
Chapter 16. When prosecutors in New Jersey and New York agreed to force Assata to stand trial on all of the indictments outstanding against her in New York before she was returned to New Jersey, they envisioned her return as a convicted felon, not a winner in every case she faced. And now New Jersey was restored as the most viable forum for conviction. Assata was again interned in the Middlesex County Jail basement, and again the National Conference of Black Lawyers filed a federal court action to have her removed. The banning of all visitors except attorneys and the weekly half-hour visit for her family, which now included Kakuya, was reinstated, and I visited her at least 3 times a week, bringing her the math book she requested to keep her mind alert. She always smiled when she saw me, but sometimes the effort she made was too painful for me to watch. Immaculately clean from her fingernails to her well-groomed hair, she walked up the stairs from the basement holding her head high, her back straight, giving no appearance of submission. We small talked about the family, about the baby, about the federal action brought to release her from solitary confinement, about nothing in particular, and we played tic-tac-toe and did crossword puzzles together. I became increasingly concerned about her obvious despair that she would not be acquitted in this trial, which grew as significantly as her color paled from a robust brown to yellow. I didn't share my feelings with her mother or with anyone else, for that matter. It was her private war, and I just did all I could to provide a little relief, continuing to work on the legal actions to release her. She wrote a poem for me on my birthday, which I think accurately describes our visits, words to NT. During these crazy times, when madness holds us in its grip and teases us with freedom, during these sorry times, when tears are not shed, because we need them to keep on getting up, during this time when words are not worth too much, we talk in whispers. Those secrets long have fled, and spend our words on tender bickering, then impatiently go on to conversations we have had before. During this time when words are flimsy hopes or empty lies, surrounding empty deeds, but in a tragic way now. Our words are all we have. So let me tell you now, I love you. Happy birthday. Keep on getting up. That was the extent of her hope as the trial approached. Theodore Appleby had replaced John Bachman as the trial judge, and his pit bull determination to succeed where other jurisdictions had failed was reminiscent of Gagliardi and Mishler and as hypocritical as the patriotic slogans used by the gang of white students in 1976 who, opposed to busing, stabbed black people on the streets of Boston with the staffs of American flags. But Appleby and Edward Barone, the newly assigned prosecutor, were more than adequately aided by the disarray of the defense lawyers. On February 14, 1976, during pretrial preparations, Raymond Brown's unanticipated motion to be relieved as New Jersey counsel had been granted. I tried to absorb the panic his absence created by remembering that Bachman had forced him to appear every day in Sundiata's trial, along with Sundiata's own lawyer, Charlie McKinney. And now, to add the months of preparation and trial appearances to the monetary sacrifice he had already made was an unreasonable expectation. Stuart Ball, a rich, young white labor lawyer, replaced Brown as New Jersey counsel and moved to admit to the case Stanley Cohen, Assata's lawyer in the Queens Bank robbery case, whom he knew. Ball's first motion was to ask the court to overturn the 1973 order changing the venue from Middlesex County to Morris County. I so vehemently voiced my objection to this unilateral action that he requested that he be relieved from the case after the court gladly granted the motion. His motion to withdraw was denied, and Lawrence Stern, another young white lawyer from New York who had limited experience with some of the BLA cases, joined the defense team along with Lewis Myers, a member of NCBL from Mississippi who had participated in the federal civil suit to transfer Assata from the Middlesex County Jail. Motions were made and motions were denied. Among the denials, the most prejudicial, as they affected our right to a fair trial, were the one asking for a free daily copy of the trial transcripts, which were automatically granted to all indigent defendants and for which Assata was eligible, and the motion that court not be held on Fridays to respect Muslim religious practice, also automatically granted in most jurisdictions. Both those motions had been ordered in the earlier part of the trial. Then Stanley Cohen mysteriously died in August 1976. The circumstances of his death and its cause have not been determined to this day. Upon his death, the New York City Police Department removed all legal materials relating to Assata's case from both his home and his office. I had to file several demands for their return from the property clerk's office where they had been impounded, and finally had to obtain a court order before they were released to me. Even so, what I received was of no value. The question about what material was withheld or destroyed still remains unanswered. After Stanley's death, Assata insisted on adding another lawyer, buying into the other's argument that the days when major criminal trials were conducted by only 1 or 2 lawyers were over. Therefore, I asked Bill Kunstler to join us. His first act, while the appeal seeking Assata's transfer from confinement at Middlesex County Jail was still pending, was to talk to Sheriff DeMarino and then hold a press conference to express his pleasure and satisfaction with the jail because it is so conveniently located near the courthouse. It was but another manifestation of the absence of coordination among the members of the defense team and of a strange unwillingness of everyone involved to accept the fact that this trial had a history. Except for Bill and me, there were no experienced criminal trial lawyers on the team, and the clashes between the others and me were serious. For the second time in my legal career, I became aware of the disdain with which men perceive women in competitive arenas, the first having been at NYU, where I was only one of a few female law professors. It was not that I was unaware of sexism, but I had always been more aware of racism, and my ability to cope with that was second nature. I was also a little unprepared because, since childhood, my best friends and closest associates had been male. I must admit I was not tactful in my comments to the other lawyers, but tact is not my strongest characteristic under any circumstances. Among the many decisions they made that I disagreed with was their plan for Assata to take the stand to relate the events of that night on the turnpike. Even though I understood it was a calculated risk that relied heavily on her proven ability to be persuasive before a jury. The problem as I saw it, however, was that first, Assata had never been subjected to cross-examination, and second, she had been living for more than a year in solitary confinement. I knew the trauma she had suffered, and I wondered if she could circumnavigate the prosecution's traps, despite her steel will to do so. But the other defense lawyers seemed to be oblivious to any effects this devastating experience might have. They met with Assata every day and criticized me for not participating in the conferences, even though I explained that when I left New Jersey, I had to travel to the Bronx to spend the night with Doris, who had just undergone a serious gallbladder operation, and to care for Kakuya. They sought Assata's legal opinion in developing a trial strategy, entirely discounting the one that had been developed by Ray, Charlie, and me in 1973. It was as if this was the first time the case was being tried, and Sundiata, sentenced to life imprisonment plus 30 years, had been convicted of a different crime. Sundiata was first sentenced to the newly created Management Control Unit at Trenton State Prison and then was transferred under the Interstate Compact Act to the highest security federal prison in the United States at Marion, Illinois, for 8 years, longer than any other prisoner. There he was exposed to tuberculosis before being transferred in July 1987 to Leavenworth, Kansas, where he remains. While Assata was a political tactician par excellence and was certainly helpful in that regard, she was hardly a legal tactician. I saw the strain as she rose to each occasion, wielding an almost hypnotic influence over the lawyers and, at the same time, needing answers herself. She became weary of them, weary of the trial, and weary of all the futile efforts. Weary, but driven to go on. The team had distributed trial assignments to each member and had decided that I would not make the opening statement, cross-examine Trooper Harper, conduct Assata's direct examination, or sum up. I watched their infighting for center stage with amazement and contempt, mixed with horrified apprehension when I learned that the lawyer who would directly examine Assata had never before performed this delicate, intricate form of questioning, which required quite different skills from those needed for cross-examination of a prosecutor's witness. Worse, he didn't even seem to understand the difference. Despite my opposition to Asada's taking the stand at all, I knew at least that if I examined her, there would be high drama, if for no other reason than our contrasting personalities and well-publicized family relationship. And of course, I had been preparing my cross-examination of Harper for years and was sick at the lost opportunity. Not that anything any of us did or did not do would have affected the outcome of the trial. But there was a significant and critical difference between my strategy and that of the rest of the team. I wanted to attack every vulnerable witness mercilessly, to exploit every contradiction, expose every lie he or she had told in every previous document or sworn testimony, including that given in Sundiata's trial, and to place every objection on the record in preparation for the appeal of the verdict, which I had no doubt would be guilty. The team, on the other hand, believed they could win despite the bias and hostility of the jurors, the judge, and the county. They approached the trial as if they could assuage this Middlesex County jury, which Appleby had ordered sequestered for the duration of the trial, by shortening the length of the trial and therefore the length of their confinement by shortening the cross-examination of the prosecution's witnesses. They believed that they would thus extract impartiality from the deeply entrenched prejudices of the jury and the court. Appleby's vindictiveness would not be appeased. When Bill Kunstler appeared before a group of Rutgers University students on October 21, 1976, and spoke about the need for all students, as well as all citizens, to be alert to injustices prevalent in the legal system, to participate in Asada's trial by their courtroom attendance, and to protest Asada's violent jail conditions, Appleby issued an order for Bill to show cause why he should not be removed from the case, citing violation of the New Jersey Canon of Ethics and his own gag order. During the 2-week hearing held in December 1976, just a few weeks before the trial was to begin, Appleby abruptly abandoned his order. Bill had testified, "I consider I have done absolutely nothing wrong. I did say I was going to refrain from public utterance that could interfere with the administration of justice, and I adhere to that," adding, "I will say absolutely nothing about this case under any circumstances. Her Sixth Amendment rights to counsel are more important than my First Amendment rights to free speech." Appleby said that he believed in Asada's right to counsel of her choice and that the necessity to avoid further delay outweighed Kunstler's questionable behavior, adding, "He may be guilty of the acts, but a fair trial has not been prejudiced." Bill had been represented at the show cause hearing by Morton Stavis, a Newark, New Jersey, civil rights lawyer associated with the Center for Constitutional Rights, but the entire defense team had been engulfed in the proceedings and had been effectively sidetracked. Undaunted, Bill filed a motion for Appleby's removal in January 1977 when he learned that Lawrence Blasey, a member of the prosecutor's investigation staff, had attended an event sponsored by Cheryl Clark, a poet and member of the Joanne Chesimer Defense Fund. The event, called An Evening of Poetry, was held at the Washington Square United Methodist Church on January 4, 1977. Harry Belafonte was the host, New York Supreme Court Judge Bruce Wright was the keynote speaker, and poets Utter Lord, June Jordan, and Susan Sherman read their poetry while I read Asada's. Blasey had appeared as a witness against Bill at the hearing aimed at his removal from the case and was the only one who had lied about Bill's Rutgers University speech, which formed the basis for Appleby's charge 161 of ethics violations. He had testified that Bill had discussed Asada's innocence, which not only was untrue but was refuted by the testimony of 2 reporters who were present and had taken verbatim notes. So when Appleby directed Blasey to appear at the poetry reading, Bill was apoplectic and charged the judge with acting in conspiracy with the prosecutor, stating, "The communications between the judge and prosecutorial authorities are violative of the spirit of fair play in American courtrooms." In his oral argument for Appleby's removal, Bill told him, "There is nothing more sacred than the defendant's right to an impartial judge. I think you will say you are impartial, but if you believe you are not, you ought to step down and not continue a charade where you have hostile attitudes toward the defendant and her counsel. Appleby retorted that the best evidence of his impartiality was the fact that Bill still remained in the trial and he refused to disqualify himself. Appleby's relentless persecution of the defense team and the National Jury Project, whom he accused of tampering with prospective jurors as they conducted their survey of attitudes in the county, extended beyond the courtroom. During jury selection, Lennox Hines, not a member of the defense team, held a press conference on January 20th, 1977, protesting Appleby's decisions and the atmosphere of partiality, unfairness, and bias he projected. Lennox accurately described the trial as a travesty, adding that Appleby does not have the judicial temperament or racial sensitivity to sit as an impartial judge. That it was only after the trial began that we began to have fears that what we are seeing is a legalized lynching, and that Appleby was asking prospective jurors self-serving questions that were leading to the creation of a hangman's court, and he stated, "It will be a kangaroo court unless the judge removes himself." And a kangaroo court means a guilty verdict. Appleby's thunderous reaction to Lennox's statements was not officially launched until the end of the trial, when he prodded the Middlesex County Ethics Committee to initiate disciplinary actions against Lennox, claiming he had violated the canon of ethics and Appleby's gag order. However, since Lennox was not one of the trial lawyers, he was not bound by the gag rule. It was only because the Garden State Bar Association, the New Jersey Association of Black Women Lawyers, and the NCBL brought federal action to stop the disbarment proceedings that Hines was finally vindicated and his license to practice law preserved. During jury selection, while the defense had 5 remaining peremptory challenges and there were still 5 jurors to be chosen, I took a day off to nurse the cold, sore throat, and fever I had suffered all week. I so advised the others the day before, adding that given the fact that more jurors would be excused for cause and by our exercise of our remaining peremptory challenges, jury selection would continue for at least 2 more days before the final panel would be chosen. At 1 o'clock, I received a telephone call from a member of the defense committee advising me that the jury had been selected that morning, that the jury box had been filled, and that opening statements would begin that afternoon. I raced to the courtroom, knowing I was too late to change anything. The explanation of the other lawyers was that the results of the field survey conducted by the National Jury Project had ascertained that all of the remaining jurors held the same degree of prejudice, so it didn't matter which ones were chosen. I not so patiently reminded them that a critical argument for reversal of a conviction on appeal had been destroyed. When the defense challenges a juror for cause, for example, for bias, and the court refuses to exclude the juror, the defense must use a peremptory challenge. The typical defense strategy is to use all of the peremptory challenges and then move for additional ones. If that motion is denied and if, on appeal, it is clearly shown in the record that biased jurors were seated, there are possible grounds for reversal of the ultimate verdict. But if the defense puts its satisfaction with the jury on the record, as it is required to do before the entire panel is sworn in, and has not used all of its peremptory challenges or has failed to move for additional ones, the argument cannot be made on appeal that the defendant was precluded from selecting a fair and impartial jury. But that was only one of the many irreversible mistakes the team had made, and Asada went to trial with a jury consisting of 5 unchallenged jurors who were either relatives or close personal friends of state troopers or of state law enforcement officers. After Barone made his opening statement to the jury and Lewis Myers opened for the defense, the prosecution put Captain James Schilender on the stand as its first witness. He had been in charge of operating the magnesium tapes on the night of the shootout, and I had successfully convinced the team that I was best qualified to cross-examine any witness who had been involved in any way with the turnpike conversations recorded on the magnesium tape, as well as the Baginski tapes and the station Bible. Even though the crucifixion I had planned for Harper was not to be, I began my cross-examination of Galinder with an innocent, inquiring tone, establishing the authenticity of the tape and his identification of each voice recorded on it. I then asked him about the procedures used by troopers on the turnpike when they made stops and under what circumstances more than one trooper was ordered to assist in making a stop for a minor traffic violation. I gradually directed his attention to the tape, which contained Palancher's voice, just after he admitted that Palancher's response of, "Meet you at the pass, partner," was unusual, unfortunate, and one he would not have made. And just as he had reached the stuttering stage in his effort to avoid the clear implication of those words that a gunfight had been anticipated, the other defense lawyer slipped notes under my hand. I glanced at them and read, "You've crossed enough. You're antagonizing the jury. This is in Brooklyn. Shut up and sit down." It was at that point, as I struggled to resume my cross-examination with some degree of composure, that I made the decision to withdraw from the case. Better to do so now, at the beginning of the trial, and use my absence from their weighty mistakes to free myself to point them out on appeal. This time, Asada understood, and I read about the unfolding travesty in the newspapers. On March 25, 1977, Asada was convicted and sentenced to life imprisonment. But Appleby's hunger for retribution had not yet been satisfied, and on April 25th he added 33 years to her sentence for contempt of court because she refused to rise when he entered the courtroom. He plunged to the depth of his hatred by directing that she be removed from the Clinton Correctional Institution for Women, to which she had been sentenced after the jury verdict, and ordered her placed in solitary confinement in the Yardville State Prison, an all-male institution in which a female prisoner had never been incarcerated. I filed an appeal from the conviction, and once again, NCBL, PROD, and I filed an action in federal court protesting the Yardville sentence. The district court dismissed the suit, and while the appeal was pending, New Jersey once again transported Asada back to the state of New York to stand trial for the two remaining indictments against her, the Hilton Hotel case and the murder of the Brooklyn drug dealer. Motions to dismiss these ancient cases, because the failure to bring them to trial sooner had denied her the statutory right to a speedy trial, were granted, the last occurring on March 24, 1978. In the interim, the federal appellate court in New Jersey reversed the U.S. District Court, ruling that any confinement of plaintiff at Yardville Correctional Facility could only be for a very temporary period, a matter of days, without jeopardizing plaintiff's constitutional rights. But by then, New Jersey had consolidated its plan to transfer Asada directly from New York to the federal prison for women in Alderson, West Virginia, by implementing the Interstate Corrections Compact Act of 1973 as soon as the New York cases terminated. With the able assistance of Jonathan Lubell, I filed an action in the U.S. District Court for the Southern District of New York asking for an injunction preventing her removal to the state of West Virginia on the grounds that the great distance between it and the residence of her appeal lawyer. The New Jersey Public Defender's Office, who thereafter appointed me its representative to prosecute her appeal, stripped her of the fundamental right of effective counsel and access to the courts, and thereby deprived her of her right to assist in the preparation of her appeal. William E. Norris, the Deputy Public Defender responsible for the operation and functioning of the appellate section of the Public Defender's Office, joined in my motion. The motion was also supported with an affidavit by Dr. Mutalu Shaker, Director of the National Task Force on COINTELPRO Litigation and Research. The New York Federal Court refused to grant the injunction, and Asada was transferred to Yardville for the transfer hearings, held on April 3 and 4, 1978. The Interstate Corrections Compact rules did not allow an inmate to be represented by a lawyer at the hearings, and Asada reluctantly acted as her own lawyer, conferring with me frequently as I sat just outside the closed doors of the hearing room. The decision of the New Jersey Corrections Department to transfer her to the Federal Correctional Facility at Alderson, West Virginia, was appealed and affirmed. Shortly thereafter, she was convoyed to the maximum security unit at Alderson and was housed with Nazi Aryan organization members who threatened her life on a daily basis, until one meaningful confrontation when she permanently dissuaded them from further efforts, advising them that if someone's mother was going to cry, it wasn't going to be mine. When Asada told me that the federal prison officials were planning to remove her to an even more remote federal prison in the Virgin Islands rather than to place her in general population once the maximum security unit had been declared unconstitutional, I filed an injunction suit in the West Virginia federal court. Whether this action forced the United States Bureau of Prisons and the New Jersey corrections officials to reconsider another transfer, I have no way of knowing. But within days, on February 20th, 1979, Asada was returned to New Jersey and placed in the maximum security unit at Clinton Correctional Institution for Women. In the meantime, I was feverishly trying to perfect her appeal. Every roadblock, every delay, every excuse was given by the prosecutor to withhold the trial transcripts and to prevent me from inspecting evidence he had admitted during the trial and still had in his possession. The clerk's office, where all motions are filed and docket sheets of the course of the trial are maintained, had misplaced most of the materials relating to the trial, so I was forced to attempt to obtain copies of motions and related orders from the defense team, none of whom could locate them. At the end of a trial, all exhibits that have been admitted into evidence by either side are returned to them. Missing was the critically important 4 pages of the station Bible, a defense exhibit, and while someone on the defense team should have had a copy, which I could have used to make my appellate point, the original entries were part of the permanent log maintained by the state police. The police refused to permit me to see the log, let alone photocopy the relevant pages, and the prosecutor's office claimed ignorance of their existence. After all of my many persistent efforts failed, I appealed to the Office of the Public Defender, documenting my attempts to obtain the transcripts and items of evidence. That office responded with a motion before the Superior Court of New Jersey Appellate Division, asking the court to order that the transcripts be produced. Mark D. Sperber, Assistant Deputy Public Defender in the appellate section of the office headed by Stanley Van Ness, who had worked closely with me during this period and without whose support and invaluable assistance I would have gone berserk, itemized in his affidavit each trial transcript that had been withheld. Additionally, I did receive 4 transcripts with critical pages missing. Mark's motion pointed out that without the use of these pages, Asada's rights to due process were being violated. Mark also said that Louis Finkel, the supervisor of court reporters in Middlesex County, had told him that he doubted whether anything further could be done to recover the missing material. The appeal was in this incomplete, compromise, and sabotage state on November 2, 1979, a day celebrated in the black community as Black Solidarity Day, when the 3:30 p.m. news flash crackled over the radio and interrupted TV programs. Asada had escaped from the Clinton Correctional Institution for Women, and a nationwide hunt for her was underway.
Catherine Massey Book Club. Have any of you heard of Black Solidarity Day? If you have, let me know. I do see, it online and that sort of thing. Dang, it was, wait a minute. So Black Solidarity Day was Sunday? Did anybody celebrate Black Solidarity Day at the beginning of the week, this weekend? Anybody know that it was this? I've never heard of that in my life, like, ever. Black, is that, so is that like the people born in the U.S., black people, or everybody that's considered black? Like, what are the parameters on the blackness here? Solidarity, wow, that's amazing. I don't have nothing to do with that, but I'm still learning. Please let me know if you've ever heard of and or participated in such a thing as Black Solidarity Day, November 2 as part of the holiday season. So I guess it's sandwiched between like Halloween and Veterans Day. Like, that's kind of would have been better if they put it in like February, May. Would have been fewer things. Maybe not in May, because you got Mother's Day, Father's Day, graduate. I don't know, but summertime, maybe July. Yeah, July 4th. You put it at the end of the month. There you go. You could have had that all to yourself. Negro Solidarity Day. I don't think they did it right doing it. Why is it in November? Is that on November 2nd for a reason? I have to figure that out. The number 720-716-7300. The code 564943 pound. Press star 61 if you would like to participate. Oh, wait a minute. Let's see. Okay, this is from Wikipedia, so I mean, you know. Black Solidarity Day is a memorial day created in 1969 by Panamanian-born activist, historian, and playwright Carlos E. Russell. It was inspired by the fictional play Day of Absence by Douglas Turner Ward. It is annually observed the day before Election Day. Okay, so that's why it's November 2. In November, the first Monday of the month. I thought November 2 was Sunday. Did they... Okay. First Monday, I guess. Okay. Its purpose is for African diasporic, okay, so this is not just the people born in the U.S., people to exercise a 24-hour moratorium from shopping or participating in other commercial activities such as using the transit system. The shopping part, I'd be with that, completely. The transit part, I don't know. I mean, I don't know. You have a lot of black people that don't have vehicles, disproportionately so. So that's putting an additional, like, are they supposed to walk? What's the plan? How are they supposed to get to work? I don't know. They have to break that down for me. So no transit. The Pan-African ideal of the observance is to highlight racial inequality and the gap between the wealthiest of one of the most powerful nations in the world and those living in poverty. So it's got some connections to counter racism. I got all that. I had never heard of this, like, ever. Black Solidarity. Why is it called Black Solidarity Day if it's to highlight, I guess it's black people anyway. Let us know if you've ever heard of and or participated in all of this. I'm still learning. It is brand new to me. Let's see. I'll finish out one email and then give my own view, see if folks have any thoughts, observations. Do not wait till the last moment. Let's see. Picking up chapter 15, number 2. Asada Melvin Kearney, Ronald Myers, 19-year-old, kidnapped a drug dealer, sent to jail for 2 years, post an enormous bail. Can you say Khalif Browder? They can nab up lots of black people and just throw you away, toss you in some sort of dungeon, and we'll come back 10 years later and bring you a bowl of water. 3. Melvin Kearney died while attempting to escape. What a shame. He might have been acquitted. Totally could have been innocent, right? Maybe he just thought no matter what, they are going to convict me of something, which might have also been true. 4. New York State lawyers voir dire of prospective lawyers. This seems way more correct than the way they do in New Jersey. I reckon. Yeah, I reckon. 5. Miss Williams' investigation, kidnapped drug dealer, long criminal record, convictions, no sentences, and red flag, paid informant or actual FBI agent. Cross-examination, admitted he was a paid FBI informant, December 16, 1975. Not guilty. Queens Court bank robbery case, January 6, 1976. Found another lawyer, Stanley Cohen, Afeni Shakur, was paralegal. Acquitted in 1976. After reading much of this text, I am suspicious of everything they accused her of. I suspect this is all just more COINTELPRO BS. Afeni was Tupac Shakur's mother. See C.O.W.S book club, Labyrinth by Randall Sullivan. She died, Afeni Shakur, in 2016. We had Mark Potok, I believe he chatted with us, or at least shared with us. I messaged him shortly after her death, which was a little curious. Some of the news reports, because I don't think 69 is too old. Just my view. Any hoodles, especially for black females. Females live a little longer in general than males, so 69 is way young, in my view. Chapter 16. Prosecutor Edward Barone died in 1992, age 48, of heart failure. Awarded the Prosecutor of the Year. Became a judge, Middlesex Municipal Court. 2. Stanley Cohen mysteriously died August of 1976. New York City police removed all legal materials from his home and office. Files related to Miss Williams, the things that she recovered were of no value. More COINTELPRO shenanigans. That is kind of exactly what I would expect, where they can go and what I would call like sanitize a scene where you have somebody who dies or some other type of crime, where maybe this is at this person's residence and they've got computer files or books, notes, whatever it is, and we're going to go and take all of this material. If it might be incriminating, if we just want it, we don't want anyone else to come and pick this work up and continue with their evidence, whatever it is, we're going to take all of this. She said that the only material we got, it was of no value. All the files on Assata's case, gone. How does that happen? Even, she said, suspicious death. Even that? What do you mean? What happened? Because you had a whole lot of those odd deaths during this time period. Even this is in the middle of the JFK trials that we read about. Abraham Bolden, MLK's death, Malcolm X's death. You got lots of those. Especially if you're connected to any sort of counter-racism effort. I mean, Medgar Evers, we got people just dropping dead left and right all throughout this time period. So what do you mean, mysterious death? What do you mean? How? Was it criminal? Was anybody charged? They say he fell asleep, in his vehicle or something, slipped on a bar slope in the shower. Let's see. She says the disdain which men perceive for women, she was not aware. She was more aware of she was less aware of sexism, more aware of racism. That was it. She was less aware of sexism, more aware of racism. Victims Guaranteed Qualified, VGQ. The fundamental problem is racism, white supremacy. She has brought that up a few times in terms of being a black female and the difficulty that she encounters being a black female attorney. I will say, she mentioned the Black Women's Lawyer Association. I looked. I said, I wonder if they have a black dude lawyer association. They do not. The Black Women's Association, they got that. The Black Dude Associate, no, they don't have that. Now, I'm not saying, if we had that, everything would be great and we wouldn't have no more racism or anything. I'm just saying they don't have no, what would it be? The New Jersey Association of Black Men Lawyers. They don't have no such institution. They got the Garden State Bar Association. That's supposed to be for African American judges. Maybe the black dudes took all that over, maybe. And they do have the Association of Black Women Lawyers of New Jersey. If you find the Association of Black Male Lawyers, Black Men Lawyers of New Jersey, or anything of the like, let old Gus T know. Let's see. The Sundiata sentenced to life imprisonment plus 30 years. Management Control Unit, Trenton State, highest security federal prison in the United States, Marion, Illinois, 8 years longer than any prisoner exposed to tuberculosis, July 1987, Leavenworth, Kansas. All I intended to inflict the most pain and torture possible. She said all intended to inflict the most pain and torture possible. Absolutely. 5, Assata, political tactician, hardly a legal tactician. I think I may have an understanding of a legal one. Not so sure about what defines a political tactician. Me either. That's a phrase I really don't use. 6, trial assignments. Infighting, contempt. The lawyer directly examined Assata. Never before done delicate questioning. Different skills from cross-examination of a prosecutor's witness. Did not know the difference. I wanted to attack vulnerable witnesses mercilessly. The team believed they could win despite the hostility and bias, racism of the jurors, judge, the county. Jury was sequestered, shortening length of the trial, shortening cross-examination of prosecutors, witnesses, extract impartiality from the entrenched prejudices of the jury and court, the arrogant mindset of those classified as white. And again, for some of these white lawyers, maybe they are playing both sides. This is their job. We're not going in here and up. We got a bunch of racists on the jury, and we're in a racially restricted region, and the judge is racist. Oh man, the best we can do is just set this up. Everybody here is racist. The jury is racist. They all hate black people. We don't even have no niggers in the county, and they objected. We did everything so we could set up the appeal correctly. They didn't do that. We're going to sabotage everything about this from the very beginning. That race soldiers, we play all sides. We heard Johnny Cochran. He told us this. Let's see. 7. An evening of poetry, Washington Square Church, New York. Harry Belafonte, cowbell. Obama mama thought he was the cutest, handsomest, sexiest thing in the world. His white mother. Judge Bruce Wright. That's Judge Turnham Loose Bruce. Black robes, white laws. All about racism, white supremacy in the courtroom. They used to hate. That's why he got that nickname, Turnham Loose Bruce, because he wouldn't say 50 years plus an additional 30 because you looked at me slick on the side and I seen you, Leroy. 30 years, bang, plus the 50. He didn't do that. He said turn him loose. All right, we're not going to do all that locking Khalif Browder and turn him loose. Turn him loose. Oh my God, we got old Bruce up here. He can't lock nobody. Just let them all out. Let them out. Turn him loose, Bruce. That was his nickname. He's dead. Oh, and I think that's a cowbell too. Anyway, he did write a book, Black Robes. White law, white justice, I think it is. Black robes, white justice, I think that's it. But the cowbell, ding, trifling cowbell too. Anyway. Lennox Hines lawyer press conference. It will be a kangaroo court unless the judge recuses himself. Asada did seem to get a lot of support from non-white people. Yes, she did. 8, for what it's worth. Jury selection, peremptory challenges, race to the courtroom, Survey National Jury Project. All remaining jurors held the same prejudice, racism. Didn't matter which ones. Choosing only one of many irreversible mistakes. Captain James Challenger. Wow, it's a new one. Challenger, okay. Prosecution witness. Began my cross-examination. Other defense lawyer slipped a note. You've crossed enough. You're antagonizing the jury. This isn't Brooklyn. Shut up and sit down. Made my decision to withdraw from the case March 25th, 1977. Asada is convicted, sentenced to life imprisonment, added 30 years. See, they give you the 50 years and they're going to add 30 on top. I wanted it because you got a bad attitude. I don't like your afro, and you didn't stand up after the trial. I want to see, like, is that legal? Like, can they add 30 years just because you didn't stand up or something? Like, that seems so arbitrary. Like, what? Come on. Says the arrogance of these racists, you would think they would give Mrs. Williams a little deference since she did get acquittals for Asada in the other trials. Like, that has no bearing. That nigger probably pulled some no-count Negro devil magic and, got these acquittals where she's old Johnny Cochran's. Yeah, see, she pulled an old slick one, see, and we should have got her then, but we fixed her wagons. See, that's the attitude they had, not no, yeah, she was maybe, no, that's not, come on. Let's see, Dr. Matula Shakur, director of the National Task Force on COINTELPRO Litigation and Research. Oh my Lord, do they have a library? They have files? Jesus Christ. Who? Make sure I check that. The New York Federal Court refused injection convoy to maximum security unit at Alderson, West Virginia, housed with the Nazi organization members who threatened her life on a daily basis. If someone's mother is going to cry, it wasn't going to be mine. Is this the same Dr. Shakur Matulu who was a member of the Black Liberation Army and convicted of a Brinks armored truck robbery in 1981? Yep. He was married to Afeni Shakur. Yep. Tupac's mother, and he was his stepfather. Yep. He died of cancer 8 months after being paroled after a 34-year incarceration. Notable inmates of Alderson. Lynette Fromm, member of Charles Manson gang. Eva the Inquino, World War II, gave propaganda broadcasts targeting American GIs, also known as Tokyo Rose. Monica Conyers, wife of Congressman John Conyers. Martha Stewart, Billie Holiday. Maybe they got the 2 golf courses and the pools there, plural. A lot of people classified as white identify with Nazis. Facts. Moreover, actual German Nazis were accepted into the U.S. government, Ike, and many other areas of U.S. society. Medicine, science. See the Cows Book Club Was Jonestown a CIA medical experiment where they also stole books from black people? Last one, every roadblock, every delay, every excuse was given by the prosecutor to withhold trial transcripts. November 2, that's Black Solidarity Day. Assata had escaped from Clinton Correctional Institution for Women. I never heard of Black Solidarity Day. Me either. It was created in 1969. Read that part. Using public internet. Seems to be unique to New York City. Maybe so. We've had a lot of people call in from New York. I'm going to have to see. Any of the people in New York, did they have like a parade this week for Negro Solid? Like nobody called any black people any names that day? Like we're going to chill out and Leroy, my bad. We ain't going to do no name calling today. It's Negro Solidarity Day. We're going to do right. My fault. Right on, Leroy. We're not going to fuss. It seems like you're not supposed to be fussing with no black people, so it shouldn't be no, wait a minute, you born where? Your grandfather's Nigerian. Oh, no, get on out of it. Nope. Supposed to be, all right, I guess you black, so for today, oh, God, I don't like that. All right, we'll get along for today. Okay, not going to, that's what, Negroes, that's what it sounds like. We're going to do that. That's old hat, Anyway, let's see. Folks, star 61, they have commentary on the portion of what we read today, the email untiljustice@gmail.com, untiljustice@gmail.com. Much obliged for the email. Make sure I didn't miss any of those, and then I'll get in a few of my notes as well. Let's see. And we are a little more than halfway through the text, boogieing on through, even though I've learned quite a bit. New Jersey state history, and always, I think, good to get reminders about COINTELPRO and just what does it mean to be classified as white. I think COINTELPRO is right on the money. They are not ignorant about no racism. I loved hearing Assata say that she requested math books to keep her mind sharp. She didn't ask for comic books, Iceberg Slim, romance novels. Bring me math books so that I can work my brain computer. Brilliant. Let's see. She said, the Theodore Appleby had replaced John Bachman as the trial judge, and his pit bull determination to succeed where other jurisdiction had failed was reminiscent of Gagliardi and Mishler, and as hypocritical as the patriotic slogans used by the gang of white students in 1976 who opposed to busing stabbed black people on the streets of Boston with staffs of American flags. Now, she does have it plural. I'm not sure that there were multiple black people stabbed with those flags, but I do know the photograph of privileged black male Ted Landsmark, who I believe is and or was an attorney, but that became the I believe Time magazine photograph of the year, him being speared by the American flag by a young race soldier, where you had mobs of whites in Massachusetts, not Alabama or Mississippi, rioting and violence, stabbing black people because they were upset about niggers being bussed into their neighborhood. Infamous moment. 1976, so this is way down the line in all of this. Let's see. She talked about Stanley Cohen, one of the attorneys, his death, and then all of his legal papers disappearing and all of this. That, man, investigate what was in the paper about all of that. Let's see. She said she was not aware of sexism. She had been always more aware of racism. And all of that, really, because I submit most black people are pretty ignorant, if not all black people are ignorant about racism. So how aware were you of racism prior to all of this? COINTELPRO hadn't just started in the 1970s with this case. So how aware of racism were you before all of this? Let's see. She said, I must admit I was not tactful in my comments to other lawyers. They say I'm not tactful either. You don't know how to talk to people, see? Let's see. And she talked about how they were effectively sidetracked because Bill Kunstler, white lawyer, suspected racist, that he is now in trouble, and the judge is saying you violated the gag order. You're going out and talking about the case and giving these, wacky speeches at these college campuses and such. And now they're having to go and be a part of his defense. And no, I didn't violate the gag, as opposed to just, we're here to get Asada out of prison, get her, free from all these charges. And now we got to be here with you, distracted, and we're wasting time and energy. You don't have infinite time and energy, as she's already told us. So we got limited everything, and we got to waste resources here with you, white man. Suspicious. Let's see. So they did not do things in a correct manner for the appeal. That also may have been done deliberately. And then when the sentencing and what have you, they sentenced her to a male prison, Yardville State Prison, where they said this has never happened for a female prisoner to be locked up there. And of course it would be Asada. I think this is something that is talked about in racism, where the total erasure, black females do not qualify as women. Black males do not qualify as men. So of course, yeah, we'll really punish, plus she got pregnant. We'll send her to a dude prison. Now, you want to be tough, rebellious? Now, make that part of the punishment. And then if we gotta send you to a female prison, we'll send you one in West Virginia, where it's way away from everybody, but hundreds of miles from your attorney, attempted relatives who like to support you and all that. They know that's important. No. And send you to where all the race soldiers, hopefully they'll kill you. And that same thing we heard with Abraham Bolden. We get you in prison, it's still Shawshank Redemption. You could easily be killed once we get you in greater confinement, especially back then. Tripped on a bar of soap, same thing I said before. Slipped on a bar of soap. Got in a fight over extra cornbread in the cafeteria. Whatever. Whoops. Guards can't see everything. You should have behaved yourself. Easy to set up. Same way with the informants and all that with COINTELPRO. And in fact, that might just be another aspect, to have all these racist gangs and the way that they operate the prison system, where you can get all the cigarettes you want and they can't do nothing about the racist gangs. Let's see. And then they got all these missing transcripts and what have you. I think we heard that before. Didn't we hear that with Abraham Bolden, where he said, man, I went to go back and get the transcript to show where they practiced racism and lied and brought in some of the same things. Got all these informants to come in and say all this stuff. And where's the transcript? Lord moves in mysterious ways. Who knows? What happened to it? Who knows? Like what? This is a fake court record. Yeah, you're right about that. But can't keep an eye on everything. We got lots of papers. Like what? What? I swear we just heard that this year. Important court, same time period, accusing black people of all these suspicious charges. And did you fabricate that? Did they really do that? The black person is saying they're innocent. Where's the trial transcript? Come on. Come on. What does it mean to be white? Let's see. She said she got 4 transcripts with critical pages missing. Marks pointed out the use of these pages denied her right to due process, which I would say is totally accurate and probably deliberate. White people are so awesome. And this is another one where I go to, now who is more informed about white supremacy racism? Who consistently has the power? That's the Black Panther Party? Any documents that are not favorable to them, they have the ability to go and snap of a finger, boop, we just disappear. Anything that doesn't make Dr. Huey P. Newton sound like a scholar, a gentleman, an egalitarian, anything that makes him sound less than that, we disappear that, shred that, that's gone. Redact. Do they have the power to do that? Usual suspects. That's That's the consistent pattern that I hear. It's us, victims of racism, people classified as not white, who are missing information, don't have it in a timely manner. It'll be something like maybe magically 50 years later, oh wow, a full copy of Assata Shakur's transcript appeared. Look at that. Where did it come from? Who knows? Lord works in mysterious ways. It'll be that type of thing. We're just waiting. Now she's passed away, so it's too late. We can't, get her out of prison. Hey, maybe she could come back to the U.S. Maybe she got family she want to check out in New Jersey and all that. Get her name quit. Nah, it's too late for all that. But we got it for a historical record. What does it mean to be white? Any hoodles. Let's see. Make sure. Didn't miss any folks who had observations and such. We still have, I think, 3 sessions or so. We're moving beyond the halfway point in the text. So be thinking significance of the text. Certainly if you have any connections to New Jersey. Haven't done any reading or serious study of the Black Panther Party. There you haven't done any serious study of COINTELPRO. This book would count. Let us know if you learned anything. If you get to do any research on Dr. Mutulu Shakur's research on COINTELPRO, if they have uploaded anything online, or if it's a physical location, maybe, even if it's a small office where they just got a few file cabinets or what have you. Wow, I would love to know what sort of information they have. Maybe they have something online. I'll check, share, let you know what I find. Anywho, we'll be here on Saturday, 8 p.m. Eastern, 5 p.m. Pacific, compensatory call-in, catch up on news observations from the last 7 days, shutdown and beyond. They just got the memorial in Milwaukee County for Sade C. Robinson. Not actually in Milwaukee City, which was talked about before. They had a racist outburst, exactly how it was described in the newspaper about this monument when it was originally suggested at the beginning of the year. But that hopefully part of the record as well. But now the monument is established again, not in Milwaukee. It is in South Milwaukee County, but not in the city of Milwaukee. But that went down this week, amongst other things, shutdown related and beyond. But we'll chat it up tomorrow, 8 p.m. Eastern, 5 p.m. Pacific. Much obliged for folks tuning in live and archive, hopefully worthy of your Friday evening. Sobriety would be hey, in the prison, you can't get toilet paper, can't get clothes, can't get food, can't get justice. You can get Newports. Sobriety would be best. Creator, we ask that you remind us, stop saying not all white people are racist. Remind us not to waste non-white people's time and energy. Remind us to maximize our time and energy to replace white supremacy with justice. Remind us not to name call people classified as black. Stop the production of throwaway offspring to be raped by Mary Kay Letourneau, drowned by Susan Smith. White women, maybe even starved. It has been time. Replace white supremacy with justice immediately. Cow signing out. Thanks all for tuning in.
Nigga, you so brainwashed.
I'm a victim, brother.
Problem. You're a victim.
I'm a victim of 400 years of conditioning.
Shut up. The man has programmed my condition. Even my conditioning has been conditioned.